Worship.
Yes.
Also, I need to mention item number 31. Also, here I have received instruction, but I'm yet to complete my affidavit. So the letter will be listed on 23rd of this month.
Lordship didn't file it is a week before to the without filing a
How long will you take to file it?
At least a week.
because last occasion Lordship direction has been denied
Yes.
was for them to file by 6th of October and it was 6 today.
Okay. So before the next date, you'll have to
Before
give
the
him
next
a chance to reply also if necessary. So within a week you file it and then we'll fix it on 23rd. Third, learned additional AG, Mr. Im Tiam Song, who's prayed for listing the matter on 23rd of October, as he has received instructions. And therefore, it is directed that the learned additional AG shall file the affidavit within a week from today, and thereafter the matter may be listed on 23/10. Yes.
Lordship is to advise kindly.
And the petitioner is also allowed to file a reply if so advised.
So I need to mention again, item number 44, that's in order. Here I get to receive an instruction,
44. Yes.
44.
Okay, how much time? How
2
much
weeks
time?
2 weeks time.
Learned additional AG, Mr. Im Tiam Song, prays for 3 weeks' time to receive instructions and to file the affidavit on behalf of the state respondents. The learned counsel for the petitioner has no objections. Lists after 3 weeks. Okay. Learned counsel, and such appears for respondent number 2 and 3. 2 and 3. Yes.
Please, Your Lordship.
Yes.
I beg to mention item 34 to 42. Analogous matter
34 to 42.
42.
Yes.
I pray this matter be listed after 3 weeks and yet to file my affidavit. I have taken the consent of the other party.
Okay. Third, learned senior government advocate, Ms. S. Mary, who has prayed for 3 weeks' time to receive
Yes.
instructions and to file the affidavit. So, learned counsel for the petitioner, Ms. Such and such is present and has no objections. List after 3 weeks. Yes.
Of that. Thank you, Lord.
Mhm.
Please, Lordship.
Yes.
May I be pleased to mention here item number 48, 49, and 50.
On consensus prayer, your lordship,
Hmm.
but I'm making number of the 3 weeks.
Learned, on the prayer of the parties, list the matter for hearing after 3 weeks. Yes.
Your lordship, I also like to mention item number 25 on behalf of AIME.
Hmm.
Your lordship, I'm informed that the pleadings are completed.
Hmm. You can
So,
list it for hearing
Yeah,
then.
in the usual course of hearing.
Learned Counsel, Ms. Devika, the government advocate, submits that the pleadings are complete and the matter can be listed for hearing. So Learned Counsel for the petitioner,
Okay, well, waiting.
hearing in usual course, okay?
No, no, the,
25.
Yes.
YP Gupta is the petitioner.
Okay.
Yes, so you're appearing on his behalf.
On behalf.
Yes. Learned Counsel, Mr. Z.N. Moli appears on behalf of Mr. YP Gupta, and he has not raised any objection. Accordingly, list the matter after, list the matter in usual course for hearing. Yes.
Your lordship, I also like to mention item number 26 on behalf of AIME.
Hmm.
Your lordship, she's yet to receive instructions, so another 3 weeks may be granted for filing affidavit.
Learned government advocate, Ms. Libika, prays for 3 weeks.
Yes, your
3 weeks time to receive instructions on behalf of Ms. AIME, Learned government advocate. List after 3 weeks.
lordship.
What about petitioner? Petitioner is not there. The petitioner has, just the petitioner has no objections. Yes. Yes.
I will mention hearing item 51 and 52.
Hmm.
Let this matter be come up on 3rd of November. I've taken the consent of the other parties.
Learned counsel for the petitioner, Mr. S. Walling, has prayed for listing the matter on 3rd November for hearing. The consent of the opposite parties have also been obtained. Yes.
My lord, again, I'd like to mention item 17 and 18.
Hmm.
Here, Your Honor, I'd like to file a writ petition within a period of 1 week. Why? Because on the last occasion, that is on duty.
Reply, you mean reply?
No, Lordship. The Lordship on 28th of August 2025.
Hmm.
Well, this writ petition was the time of the hearing.
Hmm.
This court is given a direction to file an appropriate writ petition challenging one of his letter which was enclosed in the affidavit in the position of respondent number 1 to 5.
Hmm.
So I need to file the writ petition. So I pray one being granted.
That issue, Lordship,
Mm.
there was a direction from this also.
Hmm.
The petitioners, they have filed a writ petition before.
Hmm.
So this honorable court has given a direction to the commissioner to verify whether the land is a individual land or a community land.
Hmm.
So on basis of the direction of the deputy commissioner, for this court, the deputy commissioner has verified the land and it's found out that this land is a community land.
Hmm.
He is challenging that this is inquiry report in this two writ petitions. So if he wants to file a fresh writ petition challenging subsequent development, then let him withdraw his case.
So what is the subsequent development?
Lordship, this is firstly I challenge the particular
In these two petitions, you're challenging the DC's
Yes,
verification
verification.
report.
as and then the affidavit in posting the office letter which was written by the additional deputy commissioner to the principal director. He have clarified that the verification which was done by the DC
Mm.
is genuine and then the land belongs to the community. So they are interrelated. So I was given direction to file an approved proceeding. Liberty is being granted. The court order is still lodging.
So let this.
Let's see, let's.
Lordship, let the matter be listed.
You filing a writ petition, no one is stopping you. But regarding these two, you just take some time then
Lordship, that's the reason,
for
Lordship.
17 and 18.
Okay.
There's no need to mention about the filing of the new writ petition.
Yes, in fact, the issue that is mentioning now, Lordship,
Hmm.
is just authenticating that the verification report is genuine.
Which order did the order dated?
28th of August 2025. The last paragraph, Lordship.
Basically, it's trying to challenge the clarification report on the verification.
Okay. The instant writ petitions then adjourned, granting liberty to the petitioner to file appropriate proceedings challenging the communication dated such and such. Okay, we adjourn it for full extension. Mr. Learned Counsel for the petitioner, Mr. S. Walling, has submitted that as per the order of this court dated 28/8/2025, the petitioner had been given the liberty to file appropriate proceedings challenging the communication dated 10/9/2024, as well as the clarification so given. Stop. Accordingly, he prays for 4 weeks' time
Because
to.
August month was given 4 weeks.
Mm.
Now we're in October. There's one to file.
Lordship, the
It's
reason
just-
is
it's
this.
just
Yes,
like
how
that.
much time? How much time?
1 week, Lordship.
Okay.
Reason,
Accordingly, list the matter after 1 week. 17 and 18, okay. Learned Counsel for the respondents, Mr. N. Bosui and Learned Government Advocate, Mr. M. Lonkama are present. Yes.
Let's go.
That is Malady, I take the mention item 21. In item 21,
20 and 21,
yes,
yes.
21, the petitioner and the respondents, private respondents have filed an additional affidavit.
Hmm.
To that effect, I want to file a
Reply.
reply, Lord. Malady, just 3 weeks time. To gather.
Learned Counsel, heard Learned Counsel, Mr. Foseko, for the petitioner in WPC 182 of 2024, who submits that an additional affidavit has been received from the private respondent,
Yes,
from the private respondents, and accordingly, he would like to file a reply to the same and prays for how much time?
3 weeks.
3 weeks' time. Accordingly, list the matter after 3 weeks. Learned Counsel for the petitioner, Mr. Toshi Tamjan, in WPC 165 of 24, and the Learned Government Advocate are present. Yes.
Last one. Malady, I also like to mention item 53 and 54 on the hearing list. For the petitioner. After taking the concern.
Number
53 and 54.
53 and 54, yes.
My seniors in difficulties.
Mm.
It's a big proposal, difficulties, so she can pick them up after 2 weeks.
Learned Counsel, Mr. Foseko Forte, who submits that the leading counsel, Mr. P.B. Paul, has some difficulties today, and accordingly prays for listing the matter
After 2 weeks.
after 2 weeks. Stop. Learned Counsel for the, you are for the government advocate
Not,
has no
it's a
objection.
handloom, handloom. That's autonomous
Learned
work.
Counsel for the respondent has no objection, leaves after 2 weeks. Yes.
Where's Malady?
Yes.
Thank you, Sir Lordship. Lordship, I beg to mention item number 22, Lordship.
Hmm.
Here, Lordship, I'm yet to find that analysis, so I'm going to extend Lordship.
Learned 22, yes,
no objection.
2 weeks.
2
3 weeks. Learned Government Advocate, Ms. Sajin Such, prays for 3 weeks' time to receive instructions and to file the affidavit in opposition. Learned Counsel for the petitioner, Mr. S. Walling, is present and has no objections. List after 3 weeks. Yes.
Lordship, I have similar prayer for item 27 to 30, Lordship.
27 to 30. No instructions.
No instructions.
Okay. Same order, 3 weeks. Learned Counsel for the petitioner is present, no objections.
Okay. Lordship, I beg to mention hearing item 55.
Hmm.
Lordship, I'm appearing for Mr. Toshi Olokuma.
Hmm.
Since the council is in divorce, if the matter may be listed after 2 weeks.
Learned Counsel, Ms. Asana Longkama has prayed for listing the matter after 2 weeks on behalf of the counsel for the petitioner, Mr. Toshi Longkama, who's stated to be indisposed today. Learned Counsel, Learned Government Advocate has no objections, list after 2 weeks. Yes.
Right back to mention item number 23. Lordship, I'm going to be allowed some more time to file my reply. And for a petition.
Item 23. Learned Counsel, Mr. R. Izung, for the petitioner, who prays for how much time?
3 weeks.
3 weeks' time to file a reply to the affidavit filed by the state respondents, filed by the respondents. So accordingly, list after 3 weeks.
May I please, Lordship?
Hmm.
Also, I'd like to mention item 24.
Hmm.
This was sent from litigation, but now it's reverted back here. So
Okay,
back to-
unsuccessful.
Unsuccessful.
Okay.
I'd like to ask for 3 weeks to file that.
We heard Learned Government Advocate, Mr. M. Nongkumar, who submits that the present matter was referred for mediation. However, it has returned back to the court due to, not just returned back to the court. Accordingly, list the matter after 3 weeks. You have not filed your affidavit, that means in order to enable the government advocates to, government respondents to file the counter affidavit. Stop. Learned Counsel for the petitioner is present and has no objections. Yes.
Lordship.
Next, Lordship.
Yes.
Lordship, I think we have to make one more mention from
Mm.
supplementary list.
Mm.
Item number 58.
Yes.
This morning I received a copy of the reply,
Hmm.
so I will be allowed to.
And also an additional affidavit.
Mm.
If I, rejoin the.
Learned counsel for the petitioner, Mr. Lee prays for how much time?
Lordship, yeah, and for respondent number 4.
Where's your name? Is it is it reflected?
Yes, Lordship.
That is reflected as W.
W.R. Muli, okay. W.R. Muli, who appears
Lordship.
for the private respondent.
Lordship, if I may,
Yes.
in this particular case,
Hmm.
the state has already filed our additional affidavit.
Hmm.
This one we got verification report of the DC.
Hmm.
And that verification report of the DC clearly says that the petitioner is not a landowner of that establishment.
Hmm.
And even the petitioner was present during that.
You are the petitioner.
Yes.
So you need time for
I have need time to go through the
reply of
by
the
the petition.
by the petitioner. Okay. Leonard, also what did I say? W.R. Muli for the private respondent submits that he needs some time to go through the affidavit. No, go through the reply. You file reply or additional affidavit?
Reply to the affidavit in opposition filed by the.
Okay,
respondent.
just say to go through the reply filed by the petitioner in the instant case.
Your Lordship, I also file an additional affidavit placing all the records of the findings of the Bashes under the DC office
Mm.
and the latest verification report conducted by the Chief Medical Officer Waka,
Mm.
who has established that I am one of the landowners. That
Yes,
is the
sir.
latest report.
Mm.
So
Okay.
today is not for argument. If not,
Yes,
what
yes,
my learned
it's
friend is
not for
saying is that-
argument.
Yes,
That's why I'm
so
giving
I'm
them
placing it
time.
on record.
Yes, it is stated that the petitioner has also filed an additional affidavit and the government respondents have also filed their additional affidavit. So accordingly, list the matter after 3 weeks. After 3 weeks.
Lordship.
Yes.
Mr. Lady,
Yes.
my mention number 6 on the hearing list. 6. I think here the council,
This is the only hearing item left.
he is out of station.
Huh.
Moreover, is out of station,
Okay.
okay.
So you want a fixed date?
Yes, on 27th of this month,
7.
Monday.
Learned counsel for the petitioner, Mr. Foseko Forte submits that the leading counsel is an outstation lawyer and accordingly prays for listing the matter on 27th October. Learned counsel, what about the respondents? Learned-
Respondents are.
The respondents are not represented today.
I'll inform you.
Yes, list the matter. You
Schedule,
inform them and list the matter on 27th then for hearing. Yes.
My name is interim.
The interim order passed earlier shall continue till the next day. Yes. Yes.
I'd like to mention item 19. I'm appearing on behalf of my senior, Mr. Papu Chapo. Lordship, I have a brief submission to make. So, ma'am, in this instant case, there were 2 appointments made on the basis of land ownership. And then, however, we have completed only 1 private respondent. So, we want to file one IA to complete another private respondent. So 2 weeks time may be granted to file.
Learned counsel for the petitioner, Mr. Savinsaj, who submits that he would like to file an IA in the present petition and accordingly prays for 2 weeks time to file the same. So prays allowed list after 2 weeks. Learned government advocate, Ms. Savinsaj, and learned counsel, Mr. L. Fong for the respondent number 5 is present. List after 2 weeks.
Yes, Lordship.
Yes.
As per previous occasion, I was instructed to file reply to the affidavit filed by the state respondent. So I did file my affidavit in reply to the study Lordship.
Okay. It is also submitted that the private respondent has filed the reply affidavit to the counter affidavit of the state respondents. So you have supplied copy.
Lordship. Obliged to you.
For motion, item number 1.
Yes, Mr. Zimami, actually, there is order by a coordinate bench
Yes, ma'am.
where it is said that the Act of 2013 is not applicable in Nagaland
Yes, Your Worship.
and appeal is pending.
There's another order by a coordinate bench saying that order has been passed in against another judgment of a coordinate bench, an earlier judgment of a coordinate bench, which says that the Act of 2017 applies. And so therefore, this, the judgment which your leadership is referring to is therefore very clear.
Okay, okay. Which judgment was that? Do you have a copy?
I don't have it right now.
So anyway, at this stage, we'll just issue notice, yes. So that was earlier in point of time.
Yes, that was very important.
Okay, okay.
Yeah. Then in addition, there's another point. Another point is that we have the Nagaland Land Acquisition and Acquisition Act of 1965. So there is a specific provision in that act itself, which says that so far as compensation, the assessment of compensation is concerned, it will be made in terms of the Land Acquisition Act of 1894. So by necessary implication, once the 1894 Act has been replaced by the
Whereas that one is repealed
Yes.
already.
yeah, so automatically 2013 Act applies.
Yes. Mm. The petitioner herein has referred the incident rate petition, praying for a direction to the union and the state respondents to acquire the petitioner's land in accordance with the provisions of the. Wait, okay, this is a very long
At page two of my process. Page two of my process.
page two.
Two of my process at the bottom. Right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act.
You just see later, okay? Close list also, close title also, I think it should be there. Right, yes, right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act of 2013. And also for a direction to the respondent number 6 to initiate and conclude the acquisition process for the petitioner's land in accordance with the said act of 2013. Stop. Third Lieutenant Counsel for the petitioner, Mr. Azimomi, stop issue notice general within 4 weeks. The learned
Lordship, I have for 5 and 6.
senior government advocate, Mr. N. Angami, accepts notice on behalf of respondent number 5 and 6, and Mr. Z. N. Muli, learned CGC, is accepted notice on behalf of respondent number 1 to 4. Stop. Hence, no formal notice is called for. The petitioner shall serve extra copies of the writ petition on the counsels for the respondents during the course of the day. Stop. List after 4 weeks. Yes.
For motion, item number 2.
Yes.
Lordship, the petitioner was appointed as NCD under the police department and based on a criminal case launched against him, the petitioner was suspended from service by order dated 31/7/2018. Lordship may see measure B, page 19.
It should be. Yes.
After suspension, the disciplinary proceeding was initiated. And based on the report submitted by the petitioner was again reinstated in service. Initial D page, initial C page 21. Your Lordship, in the reinstatement order, the petitioner was impose the penalty of withholding of increments for 2 years.
2 years with cumulative
Also-
effect.
Providing that the suspension till reinstatement is treated as such, not entitled for paying allowances. Okay.
So you agree by that,
Uh,
that the period of suspension till reinstatement is treated as such and not entitled for pay.
pay allowances. Lordship, I'm praying for full pay and allowances during the suspension.
Yes, I remember now. So I think you had approached this court earlier
Yes, Lordship.
and the direction was given to prefer an appeal
Yes,
before the
Lordship.
appellate authority. So where is the order of the appellate authority?
And make sure H 34, Lordship. Indian order.
Orders the honorable person section on perusal of departmental proceedings in its entirety as well. Lord General Counsel for the petitioner is such as such. The petitioner herein is aggrieved by the order dated the reinstatement order, page order dated 31st July 2018. Isn't it?
There is a suspension.
Okay, okay.
Reinstatement order.
Reinstatement order.
Is a page 21.
Order dated 13 March 2020, by which he was reinstated in service after a disciplinary proceeding was initiated against him. Stop. In the said reinstatement order, the authorities had directed that, no, the disciplinary authority had directed that he shall be imposed the penalty of withholding of 2 increments for 2 years with cumulative effect, and the period of suspension till reinstatement to be treated as such and not entitled for pay and allowances. Stop. Being aggrieved, the petitioner had filed an appeal before the appellate authority, and the appellate authority had disposed of the said appeal by the impugned order dated 26th August 2025, wherein it was held that the order passed by the disciplinary authority imposing penalty of 2 years, imposing penalty of stoppage of 2 years increment with cumulative effect, and but here there's no mention about the pay and allowances.
Your Lordship.
Only the penalty of 2 years is there.
Your Lordship, by this impugned order, the finding of the disciplinary authority was upheld.
The date of suspension, such and such. Okay, what did I say? Stoppage of penalty of 2 years increment was upheld, and the appellate authority stated that it did not find any reasons to review or alter the order issued by the disciplinary authority. Stop. Being aggrieved, the petitioner has approached this court. Stop. Issue notice returnable within 4 weeks. The learned government advocate, Mr. Thipa Pom, accepts notice on behalf of all the respondents, and hence no formal notice is called for. Stop. The learned counsel for the petitioner shall serve extra copies of the writ petition on the learned government advocate during the course of the day. Please, Dr. Flowitz. Yes.
For motion, item number 3.
Your Lordship, similar facts.
Oh, same, this one also.
Yes,
And order date also same.
Order date is also, except the suspension order date.
That is okay. Okay, same order.
Much over.
From the supplementary cost list, for motion, Item number 57.
This case also, the division bench has already stated
Yes,
the regularization process.
yes, it-
Yes.
yes. You mentioned Steve.
Mm.
But in this case, I'm on a different line. Of course, it is all connected to the same category.
It's all connected.
To the same
Yes, yes.
Okay. But it was.
So till it is decided by the division bench,
Yes,
we cannot take up this matter.
in the meantime.
Yes.
But you should kindly recall,
Mm.
in the previous litigation, as well in both the doctors' cases,
Mm.
the doctor's case as well as the nurse's
Nurses.
case,
Mm.
the directions of the Honorable Supreme Court have not been taken into account.
Mm. Yes, yes.
Yeah.
Only the direction of the union
Yes,
government
yes.
ministry,
And the directions of the ministry can be traced to the directions
to
of
the directions of the Supreme Court. Mm. Okay.
Not only that,
the-
not only that regulation,
Mm.
not just this honorable court,
Mm.
but even the Delhi High Court, a
Mm.
similar case, the
Mm.
Delhi High Court has directed regularization of all those who serve perform COVID duties.
What's it?
And the Madras
Doctors.
High Court also has passed a law on this.
Here this case is out, because they are going under a centrally sponsored scheme and they are, because there must be the centrally sponsored scheme. So it's a different.
In the. in
No,
the-
but still here also they are claiming regularization.
For regularization, they need to become.
No, they are claiming regularization
Yes,
and then the pay scale, commensurate pay scale.
and appropriate pay for service during the COVID-19 time, we also risk our lives during the COVID-19 time, and we are paid much less compared to those who are also appointed on a temporary basis for the COVID duties.
Mm. Mm.
Much less. And the Supreme Court direction is very clear, the state must take appropriate steps for the welfare of all who serve during the COVID time.
You'll see, everything has to be considered together.
Yes,
All the cases. Mm.
and in addition, this statement that we are working in the scheme, Bishop, is that there is not a tenable argument, because the leadership will also appreciate, in the doctor's case, those who are serving in missions, just like the petitioners in the mission, their cases have also been placed before their son.
No, why? Because.
Some of them were working under NHM, isn't it? Even the doctors.
Yes, yes.
But earlier they were working under NHM, but when the advertisement was published, they applied.
They applied it.
Yes, they applied.
Mm.
But here in this case, they have not applied, Roshi. They have not applied. Even though there was an advertisement for Ayush programs also, they have not applied, or maybe they applied and they were not selected.
Yes.
So it's a different thing.
Mm.
Yes.
No, the point is,
Uh-huh.
the point is leadership,
We'll see.
the direction is given to both the central government as well as state government. So these are missions under the central government, that's not a disputed point.
Mm.
But the direction is both to the center as well as to the state. And as employees of the NHM or the NAM, we are under the service of the state. The state is controlling us.
Let's see. The petitioners herein are medical officers, under bracket Ayush, close bracket, serving in the National Ayush Mission, under bracket NAM, close bracket, and the National Health Mission, open bracket NHM, close bracket, on contractual basis. The above missions are programs of the Union Ministry of Health and Family Welfare, implemented by the state government through the Department of Health and Family Welfare. It is stated that the petitioners had performed COVID duties during the COVID pandemic, beginning from the first wave. As such, they had submitted a representation dated nil, the receipt of which was acknowledged on 25/9/2024, praying for regularization of their services. Yes. By their earlier representations, they had also prayed for payment of appropriate pay in relation to Ayush doctors appointed on regular basis to the post created during COVID pandemic, who received emoluments at the pay scale of level 13 at pay matrix 56,100 17,000, no, 1,77,500. Stop. But the petitioners in NAM are receiving fixed pay of rupees 22,000 with 5% yearly increment, and the petitioners serving in the NHM are receiving a fixed pay of rupees 35,000 with 5% yearly increment. Stop. Learned counsel for the petitioner, Mr. Yusimami. Stop. The petitioners, petitioner's prayer is that the petitioners should be paid appropriate pay commensurate with their colleagues for the period of their service during the COVID-19 pandemic. Stop. Another prayer is to take appropriate steps for providing appropriate pay scale to the petitioners post the COVID-19 pandemic. Further, the petitioners are also praying for a direction to the government respondents to take appropriate steps for absorption / regularizing the services of the petitioners. Stop. Issue notice returnable within 4 weeks. The learned additional AG, Ms. V. Shukri, accepts notice on behalf of the respondents number 1, 2, 3, and 4, and learned
I serve
AGC. Okay. And the notice on respondent number 5 has been served on Mr. Learned CGC, Mr. Gauhati. Stop. The learned counsel for the petitioner shall serve extra copies of the petition on the learned counsels for the respondents during the course of the day. Let's stop the poll. Yes.
For admission, item numbers 4 to 16.
It's my lordship.
Oh, this is that UGC case.
Yes, yes, lordship. Lordship, will kindly come, take up item number 5 first. That is Tangmong and 13 others.
Item 5. WP 340.
Lordship, can it be taken up as a additional hearing?
Everyone is ready.
Yes, yes.
Can we hear? Because I noticed that there are many councils in this case.
Lordship, whether the council are present or not, it's already listed, and in the previous occasion, twice it has also been,
Mr.
order has been passed that based on the record, placed before the honorable court, it will be disposed of. That also has.
No, that is fine. Pleadings are complete, I think.
Pleadings are completed.
Pleadings are completed. I am appearing in 8 cases.
Mm.
And out of 8 cases, not all the respondents, but the selected
Respondents.
And then I have furnished a list. If required also, I will furnish even to you also. The list against.
List
whom
against
you
which
appear.
respondents you are
Yes.
appearing. That you will have to give to the private secretary, yes. You keep it. And what about Mr. El Iralu?
Who was here in the morning? He's in court number 2, Lord. In the meantime, he can.
Okay. Otherwise, the others are all there. Other councils are all there.
Worship, my senior is also present. Dennis Nelson Villa, representing some respondents.
Well, Chief, I have suggested one thing.
What we can do,
In view of the Gamboya cases, if we are to wait the competence of all the councils, it will never be taken up.
yes, yes.
But
So
since
we can take
majority
it
are
up,
present,
and then keep it part third maybe, and then take up
but
another.
we can do that.
Yes, WP 340.
Item number 4.
Yes.
Item number 5. This is.
Yes, WP 340.
I would like to list my case on Article 13, Article 141 of the Constitution of India. Article 141. Which makes Article 141 of the Constitution of India. 141. Law declared by Supreme Court to be binding on all courts. The law declared by the Supreme Court shall be binding on all courts within the territory of India. I will base my present case on this Constitution, Article 141. Then comes to Article 13 Lodge. 13 says, laws inconsistent with or in derogation of the fundamental rights. 1. All laws in force in the territory of India immediately before the commencement of this Constitution, insofar as they are inconsistent with the provision of this part, shall, to the extent of such inconsistency, be void. 2. The state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. Lordship, I will place my case on these two constitutional provisions.
Yes.
Lordship will kindly come to Annexure G3. These are the 30
Page.
G3 is page 174. There are 32 respondents, Lordship, and before this honorable board, this 32, they don't possess the required qualification as per the UGC Act. Now, this respondents were appointed, my lord will kindly allow me to read out notification. This is 29th November 2010.
My lord, we kindly appreciate that all these respondents have been appointed after the landmark judgment of Uma Devi case that was passed by the Honorable Supreme Court on 10/4/2006. This is the crux and basis of this case, Lordship. After the Supreme Court has already passed
And who are the petitioners?
petitioners are
They are also lecturers.
no, Lordship. Petitioners are net qualified. They possess the requisite qualification to be appointed as assistant professor in their respective subjects.
Okay.
My lord, we also appreciate that this case did not start just after filing the case. This case was started by account that filed PIL in 2015. Actually, this case started from 2015. That was account file PIL number 11/2025, just the background. They filed this case against OM 66, and in this PIL, the respondent government on oath placed before this honorable court the OM 66/2016 placed before this honorable court, and by order dated 5/8/2016 disposed of. The PIL was disposed of with liberty to approach this honorable court if the OM was violated. That was the first. They came before this honorable court challenging the
Who came? These petitioners?
no.
Oh.
Account.
Okay.
The case started. I am on the subject matter where this issue started with this first filing of the PIL by the account, and they were given liberty to approach this honorable court if the order of this honorable court was violated. My lord, would I be-
Lordship, before we proceed further, there are so many cases grouped together with this, up to item 16. Out 4 to 16.
Yes,
So out of all these cases, except this case, the one which my learned friend has preferred to present, all are 2023 and all are similar. But this is a case of 2022 where it was subsequently clubbed together along with the rest of the cases. So, and in this item 5, which my learned friend is pressing, the learned government council is also not present. Others councils are present. Why my learned friend has preferred to take up this, which is a solitary case, which was subsequently clubbed together along with the convoy of cases. Therefore,
Can't we
This is
take
the
up?
first
the
case.
seriousness of things,
Hmm.
it will be more convenient even for another court to
Take up the other
take up
cases.
the other group of cases, and thereafter this solitary case can be taken up later. Otherwise, after leaving so many cases which are common, and one solitary case is taken up, and if we have to switch over to the other cases which are similar, will be a futile exercise.
Lordship, this is a similarly situated cases, except
And
that
the
they
common
are
concept is not there in this particular case. In other cases, all the concepts are present.
this
So,
is 2022.
what is the difficulty to take up
Acha,
the
acha.
other similar situated
Who's
cases?
appearing in
where the
this
council-
340? Vizimo. And in the other cases, you are appearing.
In all the cases. And I'm
Except
also appearing in 8 cases. I'm also present.
they were similarly appointed, Lordship. What is the differences? This is
a
this
solitary
is
case.
solitary or no
Subsequently
solitary. This
was
is clubbed up together because it is of the same subject matter. It was all these respondents are appointed at the same time, same thing without advertisement. What is the differences in between? Except that they will claim before the court
There
that
are some respondents who are appointed through advertisement, open advertisement.
no.
Advertisement have been closed.
advertise.
in the other
Right.
petitions,
That's why we will raise the maintainability of the writ petition. On earlier occasion, they have filed, they have withdrawn. And there was no subsequent development. Again, another writ petition has been filed. Earlier, what they have done, they have clubbed together the different departments. Now,
Lordship,
they have filed separate writ
separate
petitions,
petitions.
making different
This is-
departments.
Oh,
But
these are all different departments.
yes,
Okay.
but in the same department, but
under the higher.
different department means different subjects.
Different subjects.
Subjects, because this is pertaining to assistant professor's case. Now,
Okay.
now, even in the same subject, there are some candidates who are appointed through advertisement. There are some candidates who are engaged. So we have raised serious issues on the maintainability of the writ petition. And looking at the prayer of the writ petition, they are seeking a direction to the respondent state to advertise the post, where there is no sanction post. And Lordship is well aware, to fill up or not to fill up a post is the prerogative of the government. And if there is any illegality committed by the state respondent, yes, definitely I did will lie. But here is a case where the assistant professors were engaged, most of them were engaged against non-sanctioned posts. But there are cases where the professors were on leave. For example, maternity leave. Nowadays, government is so liberal that instead of 3 months, they are called 6 months. When an assistant professor is on leave, students will be deprived if a temporary arrangements are made. Appointments like the engagement, those big posts where there is no regular sanction posts, petitioners seeking a direction to the government to advertise the post, issue a direction to the government to advertise the post, and by relying on the Omar TV's case. Omar TV is altogether in a different subject, giving you all
No,
these cases.
that is all matter of merit. But we are now on the question whether this case can be taken up separately first, or whether the other matters should be taken.
Let's take it
But this another
to-
court.
But since the government advocate is also not there, the one who's appearing in this 340 of 22. So why don't you take up the other club matters together?
Considering the nature of case and the developments, the best thing is the other cases should be taken up, and this case can be taken up subsequently, separately also.
Lordship, here in this matter. The government advocate.
Reasonable.
I don't know whether it is deliberate or not, because if one comes, another will not come, and then this has been
No,
postponed.
the others are all there. The court is ready to take up the other matters. Let's hear WBC 208 item 4.
Because this was filed at the last stage. Let's take up 189.
189. 188.
Yes, this was first, these are the first pages. Whichever it is okay, there's no differences at all. One should not be very.
188. Okay, 189. 189.
Well, 188. Then comes up. This is the first argument. Even with this logic, the two constitutional provisions that I have already read out is all the same, except that this 340 is unqualified. Otherwise, The subject matter is all the same, Lordship. So I will base my case on the Article 141 and Article 13, starting from this case 188. And the submission that I have submitted with regard to 340 is all the same. Lordship, the brief background is this. This is the first. This is the starting point of this case. Because they are pleading delay and ledgers and whatnot. So after the landmark judgment in 2006, Uma Devi's case, I'm not basing on that. But that landmark judgment, all the appointments were made.
Okay. In case there is any violation of the notification dated 6/6/2016.
Yes, Lordship. That was the first order passed before this honorable court. Right after the next day, appointments were made. Right after. The next day on 17, I have some. So the next day, just a background, Lordship. The next day on 7/6/16, the government continued contract appointments and account and public service aspirants Nagaland, that is PSAN. File read petition. These are the background that has to be covered, Lordship. PSN filed read petition civil number 145/2017. After this, challenging 706 Class 1 and Class 2 NPSC posts in 32 departments at a sweep. Then, by judgment and order dated 3/8/18, the case was dismissed on maintainability by granting liberty to the petitioners to file separate read petitions for each 32 departments, while directing the state government not to regularize any person who have completed 3 years of continuous service on contract ad hoc basis in terms of OM dated 4/8/2008 and 11/8/2016. This was the direction by the learned single judge. Now, against the direction, the state government filed writ appeal number 16/2018. The state government filed it for challenging the restraining the government from regularizing service of backdoor appointees within 3 years as per the OMs, but by order dated 7/2/2019. The writ petition was dismissed.
Writ appeal.
Writ appeal was dismissed. Having no financial resources to challenge the whole backdoor appointments separately in 32 departments, the Nagaland Net Qualified Forum, the present petitioners, filed writ petition number 12/2019 and writ petition number 65/2019, challenging the appointments of 208 backdoor assistant professors. However, by order dated 6/6/2022, the writ petitions were dismissed without entering merit and on maintainability. That in some discipline subject lordship under challenge, there being no petitioners in that particular subject and granted liberty to NNQF to file afresh. Here, lordship, in these two writ petitions, of all the subjects that were challenged before this honorable court, there were three subjects that had no petitioners in three subjects. Because of that, only after 3 years, the writ petitions were dismissed. After 3 years of proceeding, because that is 25 writ petitioners were there in other different writ petition subject matter. However, there were 3 were missing in 3 subjects. Because that only the 2 writ petitions were dismissed, again with liberty to file afresh. So, my lord, the learned senior advocate is submitting this report. This honorable court, there was something, but it is all in continuation of the first PIL that was filed in 2015, and it is in continuation that a separate petition be filed. That was direction of this honorable court, and accordingly it was filed, but because there was no 3 petitioners were missing in 3 subjects, because of that 9 other those who have the requisite qualification in subject matter, that also was dismissed. Lordship, that is how it proceeded. Then for thereafter, 18 NQQF members filed writ petition number 314, challenging the backdoor appointments of 31 assistant professors appointed without qualification, which is still pending for final hearing. That is the previous one. That is Downmong and 13 others. Subsequently, 18 NNQF members filed writ petition number 119/2023, challenging the appointments and also yearly service extension. But in the midst, notification, I have made a gist, lordship. Notification 47/2023, right after we filed the writ petition, notification 47/2023 was issued, extending the service of 148 incumbents with effect from 6/7/2023 to 5/7/2024. The writ petitions were withdrawn with liberty to file afresh to incorporate and challenge the extension notification in the present writ petitions, lordship. Then the net qualified filed 12 writ petition subject-wise challenging the present writ petition pending before the son of the court, lordship. Here, out of 115 appointments under challenge before the son of the court, lordship, 55 were appointed after OM dated 6/6/16. After the issuance that was placed before the honorable court in PIL. If my lord can specify about it. In PIL 11K 2015, they placed before this honorable court on oath that no more contract appointments will be made. But in all the writ petitions, it doesn't matter whether it is prior or after, lordship. However, for clarity, out of 115 appointments under challenge, 55, I'm taking it in total number, lordship. 55 were appointed after OM 6/6/16, ban on appointment on contract basis. after issuance on 17/6/2016, they started making appointments. The records are placed before the Honorable Court. Then appointments of 31 unqualified assistant professors under challenge have been absorbed, regularized. That was regarding the previous one that has already been withdrawn by the state. Condition of appointment. The contract service of all the 147 assistant professors are extended on yearly basis and never continuous service or on deputation. Those are the factual background before this Honorable Court.
Where is this order notification dated 6/6/2016?
I have an explanation.
Okay, and
There are so
page
many-
30, page 33, yes, that ban.
Yes,
ban
that one. Page. Shall I read out Lordship?
No, it's okay.
This is 16 June 2026 that was placed in the PIL on hold. Office memorandum subject ban on appointment on contract basis. The state government has laid down the revised procedure for appointments in government service by the office memorandum number so and so dated 26/2/2011, laying down inter alia that all appointments shall be made strictly in accordance with existing rules, procedures in force, i.e., through the Nagaland Public Service Commission, NPSC, or through open advertisement or through employment exchanges. It has been made clear in the OM that as per the existing rules in force, all ad hoc, casual, temporary, work charge appointments are banned. However, for the posts coming under the purview of the Nagaland Public Service in the event of extreme urgency, a person could be appointed on contract basis, not ad hoc, casual, temporary, work charge, etc. After placing requisition to NPSC, my lord, we kindly acknowledge these things. Be it even for a specific month, 2 months, 3 months, it has to be through NPSC. It is their office memorandum. Could appointed on contract basis, not ad hoc, casual, temporary, work charge, etc. After placing requisition to NPSC, prior clearance of NPSC, and approval of the cabinet. In the event delay in recruitment through NPSC, the contract appointment could be extended beyond 1 year with prior clearance of NPSC and PNAR department and approval of the cabinet. 2. It has been observed that over the years, the preconditions for making appointment on contract basis have been adhered to in many cases, resulting in irregularities in such appointment and their extension. A consequence of irregular contract appointment is that the government policy for reservation of posts for backward tribes is not implemented properly. Another consequence is that such appointments, being discretionary in nature, violate the principle of equality of opportunity. The Gauhati High Court in writ petition civil number 255K 2011 filed by 29 unemployed veterinary science graduate against State of Nagaland and others pronounced a judgment on 14/11/2014, holding that the rules governing recruitment to public posts and offices are required to be followed scrupulously. The court held that appointment made without following appropriate procedure under the rules holding the field and without inviting applications from open market would amount to infringement of Article 14 and 16 of the Constitution. The judgment was based on the Supreme Court's judgment in Uma Devi's case, holding that appointments made without open advertisement were ultra-vires of Article 14 and 16 of the Constitution. In view of the position brought out above, and in modification of the P&AR department's OM number so and so, dated 26/2/2001, it has been decided that no appointment shall be made on contract basis henceforth. In other words, the appointment on contract basis is banned. Thus, a post coming within the purview of NPSC can be filled up only by appointing a candidate recommended by NPSC on the basis of open recruitment, and it cannot be filled up even temporarily in any other manner. Any appointment made on contract basis henceforth shall be null and void. Lordship will kindly appreciate that. The administrative head of the department and the head of the department concerned shall be responsible to ensure that the appointment is made on contract basis and disciplinary action will be initiated against them in case of any violation. 4. This has the approval of the cabinet by the memorandum number so and so dated 12 May 2016. So this is the basis of the starting point of this present bunch of the writ petitions before this honorable lordship. Now my lord will kindly come to annexure C, E. Besides this, lordship, I will just want to bring my lordship's notice to page 28. This is the OAM of 7 July 1976. Since OAM 1976 lordship, the state government's notification, it has come to the notice of the governor that in some cases direct recruitment has been made without publicly inviting application for the post. The quota of direct recruitment or department promotion laid down is relevant service rules have also not been adhered to in the past. The government has therefore observed that any decision which violates principle of fair play, the matter is likely to leak out and to give rise to the suspicion of favoritism. The undersigned is therefore directed to request all concerned that no direct recruitment should be made without publicly inviting applications. In exceptional circumstances only, a person may be appointed to a post with prior approval of the government. The case of the appointment of a particular individuals will not fall under the category of exceptional circumstances. The need to make departure as a matter of high public policy will be only in cases like providing employment to qualified ex-undergrounds in order to rehabilitate them. The above instruction may please be adhered by all the heads of the department in making appointments to vacant posts in government department offices in future. The receipt of this communication may please be acknowledged. Lordship will then come to C1. This is 26 February 2001. Revised procedure for appointment in government. The rules and procedures for appointments of government service are clearly laid down. Despite these instances have come to the notice of the government that appointments are often being made by various departments in complete violation of the existing orders, rules, procedures governing appointments. which have been issued from time to time. The government has taken a serious view of such violations of standing orders, and in order to further clarify and streamline the procedures for appointment, the following revised guideline procedure are prescribed for appointment to government service. All appointments at all levels shall be made against existing vacant posts that have been created in accordance with rules in force. It is reiterated that no appointment of any sort shall be made in the absence of a vacant post. 2. All appointments shall be made strictly in accordance with existing rules, procedures in force, i.e., either through the NPSC or through open advertisement or through employment exchanges, as the case may be. Further, the reservation policy of the government of backward tribes shall be strictly followed in all cases where the reservation policy is applicable. 4. Lordship, I will just exclude 3. 4. The appointments to the post coming under the purview of the Nagaland Public Service Commission (NPSC) shall be made in accordance with the service rules and through the NPSC. It is the responsibility of every appointing authority to anticipate the likely vacancies and send requisition to such posts to the NPSC well in time, so that the appointment is made in accordance with the provisions of the service rules. It may be noted that service rules are framed under Article 309 of the Constitution and are statutory in nature. Therefore, all appointments should be made only through the methods of recruitment as are prescribed in the rules. 5, I will exclude, Lordship, because it's not that very much relevant. 6, if appropriate action as mentioned at paragraph 3 and above is taken in time by the competent authority, there would be no occasion to resort to temporary measures to fill up any vacancy. However, in the event of extreme urgency to fill a vacant post or where there is likely to be delay, page 30, Lordship, in filling up the post on regular basis through NPSC, the concerned department may, in exceptional cases, fill up the vacancy by appointing a person on contract basis, not on ad hoc, casual work charge. Any appointment on contract basis shall be governed by the following revised procedures with immediate effect. 1. It has to be borne in mind that the contract appointments are meant to be only a temporary measure for a limited period till the vacancy is filled up on regular basis through NPSC. It is not meant to be a permanent or long-term arrangement under any due circumstances. Lordship, here, starting from 2010 till 2018, it has been the contract appointments are being carried on. 2. No contract appointment shall be made for a period exceeding 1 year. 3. Any contract appointment shall be made only to a vacant post where the recruitment is to be done through the NPSC. No contract appointment shall be made to the post falling outside the purview of the NPSC. For posts outside the purview of the NPSC, the appointment shall be made in accordance with the rules laid out for such appointment. Then 4, subclause 4. Before any contract appointment is made, the following action shall be taken. Lordship, it's a long process.
Okay, anyway, you're trying to show that
Yes,
if at all contract appointment is made, it has to be done in accordance with this.
exactly, Lordship. Exactly, Lordship. Then D, 31D. I'll just show my Lordship that it is not just an immediate case. It has started since 1976, and all the appointments is in violation of all these office memorandums of the state government as well as the law of the land. That is what I'm trying to project before my Lordship. This is also 21st July 2018. It is consistently issued by the respondent government. And all these appointments are in violation of all these office memorandums and memorandums and the law of the land. That is what I want to impress my lordship. This is 21st July 2011. This is Regulation of Public Service Commission. I'm trying to Regulation 15 of the Nagaland Public Service Commission, Chairman, Members, Staff Regulation 2008 amended, states that all recruitment to the post carrying, this is very important logic, carrying a scale of pay of rupees 1425 to 6475, pre-revised payment of rupees 5,200 to 20,200 with grade pay of rupees 2,600 per month and above will be made through Nagaland Public Service Commission. 2. Further, PNAROM number so and so dated 26 February 2001. I have already read out. Lays down the procedure for contract ad hoc appointment in cases of extreme urgency to fill vacant sanctioned posts purely as a temporary measure. Consultation, the concerned administrative department with NPSC is a mandatory requirement in all such cases. Requisition to NPSC for recruitment against the post before conducting the ad hoc contract recruitment is also compulsory. My lord will kindly appreciate that. This is very important. Consultation by the concerned administrative department with NPSC is mandatory requirement in all such cases. Requisition to NPSC for recruitment against the vacant post before conducting the ad hoc contract recruitment is also compulsory. So before the recruitment of ad hoc and contract appointments, requisition to NPSC is necessary. Not what they are trying to project before the Honorable Court Lordship. 3. It has, however, been brought to the notice of the government that many departments are conducting recruitments in contravention to the stipulation contained in the above NPSC regulation and the procedure for recruitment laid down in OM number so and so dated 26 February 2001 by resorting to contract ad hoc appointment on long terms without placing requisition to the NPSC. We are on that, Lordship, we are on that. On a routine basis, as pointed out in a number of court judgments and also in the judgment dated 10th April 2006 of the Constitution Bench of the Supreme Court 2006 for SCC 1. All such appointments not following the laid down statutes and procedures thereof are unconstitutional and liable to be challenged. It is therefore reiterated that all departments should strictly implement the mandatory requirement of requisition recruitment post carrying a scale pay of rupees so and so with pre-revised payment of rupees so and so with grade pay of 2,600 per month to the NPSC, and in exceptional circumstances should contract ad hoc appointment be resorted to only after consultation with the prior requisition for the recruitment to the post of NPSC. It is very clear, Lordship. I need not elaborate much. D1 is submission of requisition that is issued by the NPSC, Lordship. 21st August 2014, submission of requisition. All grade pay of rupees 2,800 above, it is till date, Lordship, are to be requisitioned to the NPSC by the respective departments for direct recruitment through NPSC. So this is very specific. All concerned are therefore requested to place the requisition of posts to the Commission at the earliest to enable the Commission to proceed with the recruitment process in time. So this is annexure D1. Then this is the ban on appointment that is already read out, Lordship. Now, I would like to read out the appointment order, page 35E. As read out in the previous OM's lordship. This is just to substantiate. I may not read out the whole appointment order, but these are the appointments. This is respondent number 5 was appointed on 11 February 2011. So 11, 12, 13, 14. Right after, it will come after his 4th year, the account started the backdoor appointment lordship. The governor of Nagaland is pleased to appoint Sri E. Lichumthang Kikon, assistant professor in commerce at Dimapur Government College, Dimapur, on contractual engagement. This is what the learned senior advocate was mentioning, lordship, before this honorable court. On payment of a fixed and consolidated emolument of rupees 12,000 only per month with effect from the date of his joining the post. He is further directed to join the post within 1 month, failing which the appointment will be treated as cancelled, not accepted. The appointment is made against the retirement of Sri Bimal Chandra Dey, Assistant Professor Commerce, Dimapur Government College, Dimapur. They are saying that in case, lordship, there are sanction posts. In sanction posts, they have appointed on contract basis with a fixed pay. And this all appears to be that the state government is adopting a policy, a sort of a negative policy that appoint the highest institution assistant professor in a fixed pay without giving them whole payment. And they are just inducting them as a contract appointment with a meager fixed pay salary compared to grade 4 appointment. On my part, I'm also on that as to how government assistant professors are getting 12,000 fixed pay. Then it was upgraded to 20,000. I'm told that within this few years, it has now been upgraded to 30,000 fixed pay. Now, while in this writ petition, the Honorable Court asks the petitioners to imply the UGSC is only to let the UGC be a witness, and as to why only 30,000 is being paid by the state. On that issue only they were implicated, not in any other circumstances, only on the issue. Why the UGC was implicated is because they were being paid just 30,000, meager 30,000.
So on the direction of this court, you have implemented the UGC?
Yes, of course. They have also submitted. They have submitted that contract appointment can be made or so and so, but the objective of this honorable court is because of their giving them just a fixed pay of 30,000.
Yeah,
Yes.
5 minutes. Okay.
Right over there. No, we put it well.
Of course. You have given me enough punishments. The first part covered the entire previous. Sir, you know, you can line up. Yeah, the second one. Second one is just like. It's one minute, one
Yes.
Make a mention.
Yes.
Not that I forget that.
Yes.
Yes, maybe we'll take up the good day.
Mm.
Only the mention item, 45 and 47.
45 and 47. Yes.
After those 2 weeks.
You need time to file counter.
Yes.
Mm. Let us take a look.
The consent of the other parties also.
Okay, item 45 and 47. Right? Learned
45 and 47.
Learned CGC, Mr. Yanawati, prays for 3 weeks' time to obtain instructions and to file counter affidavit on behalf of the respondents. Learned counsel for the petitioner is present and has no objection. So please after 3 weeks. The interim orders in both the cases, the interim order passed earlier shall continue till the next date. Okay. Yes.
My lady also mentioned item 46. My lady, since the advertise going and agreement may take the whole day. Here, the respondents, I didn't get up to take that section of the respondents. That's my prayer.
Notice is not complete.
Notice is not completed.
Respondents number
3, 4, 5, and 6.
3, 4, 5.
Two, five, and
Learned
six.
counsel,
One, please, in the
learned
document.
counsel for the petitioner, Mr. Fosiko Fote, prays for some time to take first steps.
That's service.
Or Dusty.
That's the is.
Prays for permission to take Dusty service on respondent number 3, 4, 5, and 6. So why the registered notice is not returning?
It's not returning. Since they are organization.
Okay. For Dusty's service on 3, 4, 5, and 6, stop prayers allowed. The petitioner shall take steps by way of Dusty and thereafter file affidavit. List after.
It will be on 30th of October.
List on 30th October. Okay.
Anyway.
That is your lordship,
Yes.
item number 32.
Yes,
It's your lordship, the state is here to find in academy, so.
state, who's appearing for the state? Item 32. Yes,
Lordship,
okay, so 32, how much time should, 2 weeks?
Lordship, it's a case of 2025, so
3 weeks.
Your lordship, maybe come out after 2 weeks time.
Let them take 3 weeks, it's okay. Because it will take time, not yet received, I think, instructions. That learned additional AG pays for 3 weeks time to receive instructions and to file the counter affidavit on behalf of the state respondents. So prayers allowed to learned counsel for the petitioner is present, list after 3 weeks. Yes.
that's right.
Yes, so
Lordship, 35, I'm reading 35.
you're on 35.
And then next year F. This is the appointment order of the respondent number 5.
Mm.
The governor of Nagaland is pleased to appoint Sri E. Bichung Thang Kikon as assistant professor in commerce at Dimapur Government College, Dimapur, on contractual engagement on payment of a fixed and consolidated emolument of rupees 12,000 only per month with effect from the date of his joining the post. He is further directed to join the post within 1 month, failing which the appointment will be treated as cancelled, not accepted. 2. The appointment is made against the retirement of Sri Bimal Chandra De, Associate Professor Commerce, Dimapur Government College, Dimapur. 3. This is very relevant, Lordship. The contractual engagement is for a period of 1 year or till finalization of the recruitment process by the NPSC, whichever is earlier, and may be terminated at any time without prior notice from either side. So this is the condition. They were appointed till NPSC, process of NPSC, whichever is earlier. 4. The other terms and condition of this contract engagement not specifically mentioned in this order shall be governed by this department OM number so and so dated 2010-2003. So their appointment order is very clear. It is till recruitment through NPSC, whichever is there. Then F also.
F1 is respondent.
6. Respondent number 6. So this is what I'm talking about, Lordship. The date of appointment. 7 June, 6/6/16, they placed before this Honorable Court ban on appointment. That is already placed before this Honorable Court. Then the next day, on 7 June, 7/6/2016, they started making this contract appointment, Lordship. It is very clear before this Honorable Court. So this is.
So you're saying that it's against the sanctioned post?
Yes.
Which
also
test?
Against the OM dated 6/6/16 ban on appointment on contract basis.
But page 56 R6 is against a deputation vacancy, which means when the deputationist returns, automatically will be out. Page 36, your annexure F1.
35, 36.
Appointment is temporary and contractual basis against the deputation vacancy.
Yes, Lordship. The term, Lordship, the appointment is purely temporary and contractual basis against the deputation vacancy of so and so Dimapur Government College to NPSC as controller of examination. The term and condition, this is also all the same. A Lordship here.
So obviously this cannot be advertised because it's that the deputationist will return back unless he is absorbed in the borrowing department.
Lordship, here, my humble submission before the Honorable Court is not only this respondent, but even other respondents. They have been appointed for a stopgap arrangement, but somewhere, somehow, it has already become a sort of a regular service, Lordship. And this is in 2016 until date. It is in the temporary contractual basis. However, to my submission before this honorable court is that whether be it contract appointment on contract or in a stopgap arrangement, first there is a policy decision of the government and all the OMs are placed before this honorable
Okay,
court.
that is one
Yes.
aspect of the matter,
Yes,
that
yes.
these conditions have to be fulfilled before
Yes,
making the
Lordship.
contractual appointment.
Yes.
But
Lordship.
another aspect is the regularization, the advertisement part.
Advertisement, but it should be advertised.
When
and
it is a deputation vacancy, it cannot be advertised. It cannot be advertised.
Then
Okay, let's see the other orders. And actually F2.
if this is F1, then F2 are respondent number 7 and 8. 7 and 8, that is e-commerce Lordship. Serial number 1 and 2.
Okay.
So these are
Page 7, respondent 7 and 8.
seven and 8.
They-
Here, it says the governor of Nagaland is pleased to temporarily engage the following assistant professor in sociology, commerce, and psychology in the following government colleges shown below, consequent upon introduction of new subject on a fixed pay of rupees 20,000 for a month, per month, for a period of 1 year. The arrangement is temporary basis and can be terminated anytime
So
without.
here also it is clear that there is no post. There is no sanction post.
This appears to be. Then there is 139.
Then
The next page, psychology. This is serial number 2. This is unqualified. 139.
page 38. Serial number 2.
She will be in that Townhouse case, Lordship, the previous one, that unqualified.
So
I'm sure it will- Then, next year,
okay, so this page 38, serial number 2 is not the respondent here.
respondent.
No, her name is not here.
Yes, she's not here. She will be in the next 314. Then
Page
it's
30.
24th August. All these are after 6/6/16, Lordship. All the appointments. Except the number 1. This is also impartial modification in this department's notification of even number dated 14 July 2016. And consequent upon the non-acceptance, the following candidates in waiting list are temporarily engaged as assistant professor indicated below. This is one Srimati Nukshisangla Lemtur, Commerce, waiting list number 1, is temporarily engaged as assistant professor commerce against the non-report of Srimati Menothore and posted as assistant professor fixed, Dimapur College, Dimapur. Then only respondent number 9, serial number 2. Respondent number 9. This is pertaining to commerce subject Ruchi.
Okay.
In many of the notification, all the subjects are club up together. Then F4 is
What is this non-report, no acceptance? Even number.
some other may have been selected. However, since he or she did not report in that replacement, assumably Lordship. So 7th August 2018. Next year, page 40. In the interest of public service, the Governor of Nagaland is pleased to engage Sri Meren Jamir temporarily as Assistant Professor in Commerce at Government College, Dimapur, on payment of a fixed and consolidated enrollment of 20 rupees per 20,000 per month with effect the date of his joining the post. 1. The engagement is made purely on temporary basis against the retirement vacancy of Sri Bantungo Lotha, Associate Professor. 3. 3. The contractual engagement is for a period of 1 year till the post is filled directly by NPSC, whichever is earlier as may be terminated and may be terminated at any time without prior notice from either side. This will do, Lordship. Just to show this respondent number 10. This respondent number 10.
Page 11 is respondent 11.
Then respondent number 11 is 541, page 41. This is Srimati Moza Senior Pyo, temporarily appointed as Assistant Professor Commerce at Kohima College, Kohima, on payment of fixed consolidated emolument. This is also engagement is purely on temporary
basis without sanction post.
Without sanction post, yes, Coach. Respondent number 11. And now, next year G, Lordship. This is the writ appeal that was, I will rely on this. Writ appeal number 16K 2018. This is State of Nagaland versus Account Against Corruption and Unvetted Taxation and 119 others. Lordship will kindly come to page 43. Shall I read out, because all the writ petition also is covered by this case.
Okay.
Paragraph 4. Paragraph 4 it says, the appellants also placed before this honorable court that in the said OM dated 4/8/2008, it has been specified that there shall be a suitability test to be conducted by the concerned department under the chairmanship of the head of the administrative department with representative from Personnel and Administrative Reform Department and Administrative Training Institute, Nagaland, Kohima, and that the qualifying marks would be laid down in advance, and only those who qualify such a screening test will be considered for regularization. In the said OM 4/8/2008, it was also stipulated that concerned department after screening shall submit specific case to the government for its approval for obtaining the recommendation of the screening committee that comprised of the chief secretary as its chairman, the additional chief secretary home, the principal secretary PNAR, the commissioner and secretary law as member. 5. The joint secretary PNAR as member secretary to the screening committee, to the said screening committee. 5. Mr. K. Sema placed another office memorandum bearing number so and so, dated 6/6/16, before the court that it was issued by the state government in the Department of PNAR, where it is specified that from the date of issuance of the said OM, no appointment shall be made on a contractual basis, meaning thereby that appointment on contract basis was banned, and further observed that a post coming within the purview of NPSC can be filled up only by appointing a candidate recommended by NPSC on the basis of open recruitment, and such posts cannot be filled up even temporarily in any other manner, and that any appointment made thereafter on contract basis shall be null and void. Lordship. Then, shall I read out the whole thing or
No,
just?
the operative portion, the observation of the court,
Okay, Lordship.
the observation of the court, I think from
There
paragraph
was
10.
no observation. The previous single judge order was reflected and then it was dismissed, Lordship. Then shall I read out paragraph 10, Lordship?
Paragraph 10, I think. 10,
46
11,
page.
yes.
Yes, here, from the perusal of the writ petition number 145K of 2017 preferred by the petitioners, the respondent herein, as well as the impugned judgment and order dated 3/8/2008 passed herein by the learned single judge, we have seen that prayer in the said writ petition, amongst other, was to set aside and quash the impugned office memorandum dated 4/8/2008 and 11/8/2016 of the state government, by which the state allegedly provided for regularization of the backdoor appointees who were appointed on contract ad hoc basis in public posts under the state government prior to the office memorandum dated 6/6/2016 came into force and have completed 3 years of such service. In the said writ petition, the petitioner have also prayed for termination of service of such 706 backdoor appointees in government service serving in various departments of the state who were appointed prior to 6/6/2006, and to direct the Nagaland Public Service Commission for general recruitment to those 706 posts under various departments of the state within time-bound period. The contention of the writ petitioner in the said writ petition number 145K of 2017 was that the state respondent decided to regularize all those backdoor appointees made by the state in public posts under its various departments on contract ad hoc basis in terms of those OMs dated 4/8/2008, 11/8/2016 in violation of the direction of the Honorable Court in the case of State of Karnataka versus Uma Devi 3, reported in 2006 for SCC 1. From the impugned judgment dated 3/8/2018, we have seen that the learned single judge, after deliberating the matter at length, found that the action of the state government in regularizing of the employees who have completed 3 years of continuous service on contract ad hoc basis in terms of the said OM dated 11/8/2016, as well as OM dated 4/8/2008 is in violation of the law laid down by the Honorable Apex Court in case of Uma Devi 3 Supra. 12. At paragraph 28 of the judgment, impugned judgment and order dated 3/8/2018, learned single judge observed that 28. The judgment of the Apex Court as quoted above thus clearly gives primacy to advertisement before filling up vacant posts as per the recruitment rules in force. The state respondents should accordingly consider filling up the regular vacant posts under the state government as per the law laid down by the Apex Court, and any contract ad hoc employees who is appointed to the post on contract basis should also be able to participate in the selection process, provided the person is eligible for same as per recruitment rules and is not regularized as per para 53 of the case Uma Devi 3 Sopra. In view of the laid down by the Apex Court, any contractual, temporary, or ad hoc appointments made without prior advertisement being issued in the media, including newspapers, will be violative of Article 14 and 16 of the Constitution and liable to be set aside and the said post filled up as allowed as per law. However, the question of filling up the said post will come into play after the said respondents have taken recourse to paragraph 53 of Uma Devi 3 Supra. 13. The learned single judge in the said judgment and order dated 3/8/2018 observed that the petitioners made a sweeping challenge to the appointments made in various grades of posts in approximately 25 government departments, thereby trying to brush aside all alleged irregularities and illegalities with one sweep of the broom, and that it is very difficult for the court to see through the facts of the case in the absence of complete material facts. In respect to the challenge made to 706 alleged illegal appointments. As such, the petitioners were allowed to file separate petition making a challenge to the various appointments by giving specific particulars as their grievances relates to different appointments in various departments of the government of Nagaland, observing that the said writ petition cannot be decided piecemeal. For such reason, the learned single judge found that the said writ petition is not maintainable in the form, and the petitioners had filed the same, but gave the liberty to them to make a fresh challenge to the appointments of the impleaded respondents and other persons as per law, since the said writ petition was not dismissed on merit, but only on the issue of maintainability. 15. However, with regard to order dated 5/8/2016 passed in PIL number 11K/2015, the learned single judge observed that at best, the same is applicable to the petitioner number 1, who preferred the said PIL, the respondent number 1 herein only, and not to the other petitioners of the writ petition. 16. The Constitutional Bench of the Honorable Supreme Court in the case of Uma Devi 3 Supra at paragraph 53 observed as follows. On the aspect needs to be clarified. There may be a case where irregular appointments, not illegal appointments, as explained in S.V. Narayanappa, AIR 1967 SC 1071, R.N. Nanjudappa 1972 1 SCC 409, and B.N. Nagarajan 1979 4 SCC 507, and referred to in paragraph 15 above, of duly qualified person in duly sanctioned vacant post might have been made. The employees have continued to work for 10 years or more, but without the intervention of orders of the courts or tribunals. The question of regularization of the service of such employees may have to be considered on merit in the light of the principles settled by this court in the cases referred and in the light of this judgment. In that context, the Union of India, the state government, and their instrumentalities should take steps to regularize as a one-time measure the service of such irregularly appointed who have worked for 10 years or more in duly sanctioned posts, but not under cover of orders of the court or of tribunals, and should further ensure that regular recruitment are undertaken to fill that vacant sanctioned post as required to be filled up. In cases where temporary employees or daily wages are being now employed, the process must set in motion within 6 months from the date. We also clarify that regularization, if any already made but not sub judice, need not be reopened based on this judgment, but there should be no further bypassing of the constitutional requirement and regularizing or making permanent those not duly appointed as per the constitutional scheme. The Honorable Apex Court decided said case of Uma Devi 3 on 10th April 2006. In the said case of Uma Devi 3 Supra, their lordship have specifically observed that regularization of service of only irregular appointees can be considered and not of illegal appointees. Further, regularization of those irregular appointees who are duly qualified persons placed against in duly sanctioned posts who have continued to work for 10 years or more without any intervention of orders of the court or of tribunals can be considered. The Honorable Apex Court in the same case further observed that regularization of such category of irregular employees have to be considered. That too on merit in the light of the principles settled by the Sixth Honorable Court as laid down in the case of S.V. Narayappa Supra, Aran Namju Dapa Supra, B.M. Nagarjan Supra, as well as in the light of the said judgment, i.e. Uma Devi 3. Accordingly, by the said judgment, the Honorable Court directed the Union of India and the state governments and their instrumentalities to take steps to regularize such irregular employees as a one-time measure and directed the authorities to ensure that regular recruitment are taken up to fill up those vacant sanctioned posts that are to be filled up. In cases where temporary employees or daily wagers have been employed, and such process of regularization should be set in motion within 10 months from the said date of the judgment, 10th April 2006. 18. In the said judgment of Uma Devi Supra, the Honorable Court with regard to such regularization of service of irregular appointees clarified that based on the judgment, if any regularization is already made but not sub judice, such case should not be reopened. At the time, the Honorable Apex Court issued a strict rider that there shall be no further bypassing of the constitutional requirement and regularizing or making permanent of those who are not duly appointed as per the constitutional scheme. 19. As such, in terms of the judgment of Uma Devi 3, anyone appointed in violation of constitutional scheme on, Lordship, this is very relevant because in other cases also the respondents are bringing up this issue of better appointment that they are irregular appointees and those who have reached 10 years can be regularized. That is being placed before the Honorable Court, not only in this case, but in other cases also. But the cutoff date is 4/10/2006. That is the cutoff date, and Supreme Court has already, I have also citations, given that confusion to do away that confusion. It has been upheld that the cutoff date is only 10th April 2006. Before that, those who have reached 10 years. But it's not a question of again after 2010 for 2006, appointing and after 10 years of service, regularizing them. Respondents are pleading before the Honorable Court on that, on misconceived notion to mislead this Honorable Court. Not only in this case, but in other cases also. So it is very clear, Lordship. It is also have been very clear that such process of regularization should be set in motion within 6 months from the said date of judgment, i.e. 10th April 2006. In, yes.
Okay, so
18. In the, because I'm not going to read out that very long that Uma Devi judgment anymore. This will cover, Lordship. So 18 it says, in the said judgment Uma Devi Supra, the Honorable Apex Court with regard to such regularization of service of regular appointees clarified that based on the judgment, if any regularization is already made but not sub judice, such cases should not be reopened. At the time, the Honorable Apex Court issued a strict rider that there shall be no further bypassing of the constitutional requirement and regularizing or making permanent of those who are not duly appointed as per the constitutional scheme 19. As such, in terms of the judgment of Uma Devi, anyone, this 19 is very relevant, Lordship. Anyone appointed in violation of constitutional scheme on or after 10th April 2016 are not entitled for regularization, and that too, only those irregular appointees who are duly qualified, placed against the duty sanctioned vacant posts, have completed minimum of 10 years of their service as regular appointees as on 10/4/2006 and serving without any intervention of orders from the court or tribunal can be considered for regularization as one-time measure, subject to the condition that the Union of India, the state governments and their instrumentalities, as the case may be initiated, the process for such regularization within 6 months from 10th April 2006, i.e., the date of judgment of Uma Devi 3 Supra. 20. The Honorable Apex Court have already settled as to who are irregular appointees and who are illegal appointees in service with regard to public employment and posts under the government, where salaries are paid from public coffer, state largesse. It is settled that when an illegality is brought to the notice of the court in judicial proceeding, more particularly in a proceeding under writ jurisdiction, the court cannot shut its eyes and allow the authorities to continue with such illegalities. 20 is very relevant. 21. The learned single judge in the impugned judgment and order dated 3/8/2011 passed in writ petition number 145K/2017 found that the action of the state government regularizing the service of the employees who have completed 3 years of continuous service on contract ad hoc basis in terms of those office memorandum dated 11/8/2016 and 14/8/2016, 4/8/2016 is in violation of the law laid down by the Honorable Apex Court in the case of Uma Devi Supra. As such, the impugned decision of the learned single judge 3/8/2018 disposing of the said writ petition number 145K/2017 being not maintainable in the form it was filed without dismissing the same on merit and granting liberty to the petitioners of the said writ petition to make fresh challenges to the appointments of the impleaded respondents therein and other persons as per law. We are of the view that the learned single judge did not commit any illegality in directing the state respondents, the appellants herein, not to regularize any person who has completed only 3 years of continuous service on contract ad hoc in terms of those office memorandums dated 4/8/2016 and 11/8/2016 noted above, as those OMs are found to be not in conformity with the law laid down by the Honorable Apex Court in the case of Uma Devi 3 Supra. 23. Accordingly, we are of the opinion that the direction and observation made in the impugned judgment and order dated 3/8/2018 passed by the learned single judge in writ petition civil number 145K/2017 does not call for any interference. For the reasons above, this writ appeal is being devoid of merit stands dismissed. So this is the Lordship, this is the judgment order passed in writ appeal. And
Then after that, what is this, page 51?
yes, this is 51.
Oh,
Is
extension.
said notification, that is extension.
Extension.
Extension is
Extension
not a-
order of the private respondents.
Yes, all the private respondent with their different subject are before the Honorable Court. These are the same extension. It was we withdraw the 2 writ petition that was filed and immediately on filing the 2 writ petitions, they issued this. So in order to incorporate this in all the writ petition, we withdraw that 2 writ petitions with liberty and incorporated this. This is extension with effect from 6/7/2023 to 5/7/2024. Now it has expired. We are unknown whether their service has been extended or not. Here, the crux of the case is lordship. Till 2024, all the respondents are their service is extended by 1 year. Always, every year. That it shows that there is no chances of they continuing in the post that they are holding. They don't have the right to hold the post, and that's why we are challenging this we challenge this extension order also. And all the respondents are hearing, except there are some respondents left out from this notification, extension notification. Those the petitioner do not have the required qualification to challenge as per the direction of this honorable court, subject wise.
So this one is commerce.
This is commerce.
And the petitioners are also holders of.
Yes. The petitioners in all the 12 writ petitions, petitioners having requisite qualification are challenging the appointment orders of the those having the subject appointed lordship. So these are the crux of the case is only that lordship.
Okay.
And I don't want to this honorable body in judicious court in your wisdom knows that this is about the backdoor appointment, and I will just rely on the judgment of the Supreme Court's authorities and only on the.
Wait. Before that, you just come to your prayer once.
Yes.
Prayer is to squash and set aside the appointment orders. Appointment orders, isn't it?
Yes, Lordship.
Appointing, then like the extension orders.
I have sorted out which are the sanction posts, which are non-sanction posts.
And to requisition the 3 sanction posts.
It is very clear, Lordship. I have
3 sanction posts of R5, 6, and 10. But your prayer prayer E is not possible because when there's no post, how can it be advertised?
Lordship, I will just leave it to this honorable court's.
Only 5, 6, and 10 are holding sanction posts, isn't it? 5, 6, and 10.
Lordship,
5.
even if it may not be sanction post, it may not go through the NPSC, Lordship.
6 is also deputation.
My humble submission before this honorable court, in all the repetitions, Lordship, just there are so many who are not appointed in a sanction post. Now, Lordship, they were appointed in a non-sanction post. To my understanding, Lordship, I place before this honorable court that even be it in a non-sanction post, it may not go to NPSC as a regular recruitment, Lordship. But all the non-sanction posts also there has to be an advertisement. That is my humble prayer only, nothing else. I'm not against any individual or authority or so, but the question here is most of them are all appointed in a non-sanction post. So be it even in a non-sanction post on contract, the post has to first be advertised. Otherwise, they cannot go on continuing appointing the respondents in a non-sanction post and continue for 10, 20 years, Lordship. That is my humble submission before this honorable court. It need not go through the NPSC, non-regular sanction post. But the department has to advertise, they have the authority to advertise, any department. Now, UGC Regulation 2010, Lordship, I'm sure I have given the regulation previously because almost it was more than part heard also. But then again, it was kept pending, Lordship. So in the previous occasion, I might have submitted the UGC regulation of 2010, 2018, Higher Education Rules 2003, Nagaland Higher Education Service Rules 2015. All those.
UGC regulations are here.
Yes, Lordship.
Then notification. Another notification, UGC notification of 18 July 2018 is also here.
Yes, I have already submitted this. In fact, a long process of hearing had already taken place, Lordship.
Then
But
what
then
happened? Then
just-
it was released.
Yes, something like that, and at the end, again, because of the UGC, the case was kept pending up to this extent, Lordship. It took them more than 1 year to return the service. That is the problem. There was big confusion. So the Department of Higher Education Service Rules 2000, the first 3rd October 2000, 13th October 2003, it covered the previous service till it was repealed by the Nagaland Higher Education Service Rule 2015 Lordship. So I just want to.
That service rule is not here. Maybe.
Yes, Lordship. See. All the appointments are in violation of the rules. That is what I'm now trying to
Okay.
address this on our
Let's
report.
see.
My lord, we kindly come to till 2015. This covered the service condition of the assistant professors. My lord, we kindly come to page 5.
Till 2015.
15, yes. This service rule is repealed by Nagaland Higher Education Service Rules 2015. I will come to that, but the portion, some of the respondents who were appointed prior to 2015, I'm trying to cover them up. So this is the method of recruitment is?
Rule 9.
Yes. Method of recruitment also is by direct recruitment and only by promotion logic. Rule 8. There is only 2 methods. That is by direct recruitment and by promotion. No contract, no ad hoc, no backdoor logic. Then 9.
Yes.
So logic 9 is direct recruitment. 1. Roman 1 logic. Whenever there is a vacancy or expected vacancy in the service to be filled up by direct recruitment, under these rules, the department shall immediately send a requisition in the form prescribed by the commission indicating the subjects or academic disciplines and the number of vacancies. 2. Roman 2. The commission shall advertise the post specifying as far as possible the terms and conditions under these rules and the number of vacancies to be filled up. Now, Lordship, you kindly come to Schedule 2. Schedule. Last page, Lordship. Lecturer, librarian. Before it was lecturer, now
Junior grade.
redesignated as assistant professor, junior grade. It's 100% direct recruitment, Lordship. There is no promotion or placement also. The posts of lecturers and librarians shall be filled up by direct recruitment of candidates who possess the required qualifications prescribed under Rule 10. Then is the qualification, Lordship. But here it will come in the previous repetition, Lordship. Otherwise, the qualification,
Then
yes, Rule 10 is the qualification, Lordship.
master's degree from
Recognized university in the subject with minimum 55 marks, relaxable by 5% for the SC, ST category. B, good academic record. 3, C, preference will be given to candidates who have cleared the National Eligibility Test NET for lecturers conducted by UGC, CSIR or similarly tested accredited by UGC. This will do, Lordship.
So at that point of time, net was not compulsory
Lordship,
under this.
who have cleared national eligibility?
No, preference, it only says preference.
Preference.
Preference will be given. Otherwise, in these rules, net is not compulsory.
But, Lordship, here the question is, of course, here it is.
We're
but the
going
question
by
is
Rule 10.
advertisement.
Yes.
It is only, we are only on the advertisement, so.
No, I'm just
this-
looking at the
Yes,
qualification.
it's just on the question of advertisement.
Yes, yes.
So this is 1000.
And what about the UGC regulations? What do you want to show from here?
2015 rules, Lordship.
Oh,
Yeah,
2015
it
rules.
was now enforced.
Yes, the copy is not there.
Submitted.
No, maybe it's in the other files.
Oh, then it is here.
This is.
Page 3, methods of recruitment.
2000.
Here also, Lordship, in continuation, the method of recruitment to the posts specified in Schedule 1 shall be as follows: by direct recruitment and by promotion. Only two aspects.
Yes, that is understood. And then
Then direct recruitment, it's all the same. It carries the same statement.
then schedule, now it is assistant professor.
Yes, Lordship. Now assistant professor. Then 8 is the qualification for direct recruitment.
Okay.
It's the same as the previous one. Then, Lordship, here is 2015 qualification as that was previously, it was not mandatory as my Lordship has made.
Now it's mandatory.
It's mandatory, Lordship,
After 15.
after 15. And this came into force since 2015. There is also clause C. Now, not only this net, but those candidates who have been awarded as a PhD degree also are eligible, Lordship, not only net.
The first page is missing,
The first
this one.
page.
So rule 1 to 5 is not here.
Fine. One.
Because the effective date,
Yes,
the
yes,
effective date will be on the first page.
okay. My Lord wants to see I also have this, how that was missed out. I beg your pardon.
You just provide the first 2 pages. No, here also same thing.
Oh,
Oh, no, this with effect from the date of publication. Okay, then?
then, so this is the 2015. Then there is UGC rules, 2010, I think I have already submitted. Lordship.
UGC regulations on minimum qualifications, 30th June 2010.
Yes. My Lord, you can see page 4.
36, 2010.
3.30. Recruitment and qualifications. 3.30 and 3.31. Oh. Lordship, you have this 2010.
This is 36, 2010.
Yes, 36. I have it. Oh, I have it also.
Recruitment and qualifications, yes.
Then,
So 3.3.1 net as let said
Yes.
shall remain the minimum eligibility condition here.
and Lordship will kindly come to page 58.
If date of
I might have attached there, maybe not, it's so bulky that I did not attach there, but
no, there are 2 notifications, UGC regulations of 36, 2010 and another one of 18/7 2018.
Lordship 58 is there, I have a next. The last second page. 58, down. Lordship can take this.
No, it's here.
Oh, it's here.
Recruitment and
I
qualification.
just want to bring my Lordship to the notice of 13-0, appointment on contract basis. They are relying on that, that's why. Here, I just want to read out Lordship. 13-0.
13-0.
Yes,
Page.
the last second page. Right, the next. The page is 58.
Page 58 of this Gazette notification.
Yes, 2000. It's 2010.
Appointment on contract basis.
Yes.
13.0.
Yes.
Yes.
I'm referring to that.
Yes.
Appointment on contract basis. 13.1. The teacher should be appointed on contract basis only when it is absolutely necessary and when the student-teacher ratio does not satisfy the laid down norms. In any case, the number of such appointments should not exceed This is very relevant, Lordship. 10% of the total number of faculty position in a college, university. The qualifications and selection procedure for appointing them should be the same as those applicable to a regularly appointed teacher. So in other words, it should be through advertisement, Lordship. This is up to 22. So 10%. Now here in Nagaland, about 70% is on contract basis. That is what I'm trying to project for the Sonam report. The UGC provides for not to exceed 10%, Lordship. 10% of faculty position in a college or a university. Here, about 70% is on contract in Nagaland. That is my humble submission for this honorable court. And the procedure is by regular recruitment, regular selection process. As those regularly appointed, that means it has to be through advertisement under whatever circumstances. Not to exceed 10%. That also under regular recruitment process as regularly appointed. So this is of 2003. Now, my lord, we kindly come to 2000. The latest in force, 18 July 2018.
It's time, please continue.
Lordship. It's my God.
Hmm.
Kochi, the UGC
No,
certification.
18 July.
Yes. Okay, so should we begin how to? Page, second page. Section 4. 30. Recruitment and qualification.
Three point
30.
oh 3.0.
Yeah, 3.0. Recruitment and qualification. The direct recruitment to the post of assistant professor, associate professor, professor in the university and colleges, the senior professor in the universities shall be on the basis of merit through an all India advertisement followed by selection by a duly constituted selection committee as per the provision made under these regulations. The provisions shall be incorporated in the statute ordinances of the university concerned. The composition of such a committee shall be as specified in this regulations. 3.2. The minimum qualification required to the post of assistant professor, associate professor, professor, senior professor, principal assistant, librarian, deputy librarian, assistant director of physical education and sports, deputy director or physical education and sports and director of physical education and sports shall be as specified by the UGC in this regulation. 3.31. The national eligibility test NET or an accredited test state level eligibility test SLET SET shall remain the minimum eligibility for appointment of assistant professor and equivalent position wherever provided in this regulation. Further, SLET SET shall be valid as the minimum eligibility for the direct recruitment to the university, colleges, institutions in the respective state only. Then, second page 9. 3.12. Qualification. Here also qualification. 4.0 direct recruitment. Then 1 assistant professor eligibility A or B. A sub plus 1. A master's degree with 55 marks for an equivalent grade in a point scale wherever the grading system is followed in a concerned relevant allied subject from an Indian university or an equivalent degree from an accredited foreign university. Then 2. Besides fulfilling the above qualifications, the candidate must have cleared the national eligibility test, NET, conducted by the UGC or the CSIR, or a similar test accredited by the UGC like SLET, SET, or who are or have been awarded a PhD degree in accordance with the University Grant Commission minimum standard and procedure for award of MPhil PhD degree, Regulation 2009 or 2016, and their amendments from time to time as the case may be, exempted from NET, SLET, SET. So this is the qualification. Now coming to, I might have a next slide before Lordship, page 94. Appointment on contract basis. Thirteen point zero. Last second page.
Yes. Appointments on contract basis.
Yes, it is. Yes, appointment on contract basis here also it is provided. And I don't deny. 13-0.
In any case.
Appointment on contract basis. The teachers should be appointed on contract basis only when it is absolutely necessary and when the student-teacher ratio does not satisfy the laid down norms. In any case, the number of such appointments should not exceed 10% of the total number of faculty position in a college, university. The qualification and selection procedure for appointing them should be the same as those applicable to a regular appointed teacher.
Same like the earlier regulation.
Yes, same. Lordship. To finish off this, the fixed emolument paid to such contract teachers should not be less than the monthly gross. Why the UGC is implemented is because of this. After a long hearing on reading this, they were asked to be implemented. Fixed emoluments paid to such contract teachers should not be less than the monthly gross salary of a regularly appointed assistant professor. Such appointments should not be made initially for more than one academic session, and the performance of any such entrance teachers should be received from academic performance before reappointing him, her on contract basis for another session. Such appointments on contract basis may also be resorted when absolutely necessary to fill vacancies arising due to maternity leave, child care leave, etc. So these are the latest provision, and it is very specific that the qualification and selection procedure for appointing the respondent should be the same as those applicable to regular appointed teachers. That is by way of advertisement. That is this portion is finished. Lordship, I just want to bring my lordship to para 7 of my repetition. It's just short, since there is nothing much to argue about. Yes, but para 7 pertains to the eligibility criteria of the respondents, sanction post, non-sanction post of the respondents. 6 to 11. It can be referred here as well as in the prayer section also. Then my lord, kindly come to, this is one aspect also. Before, when the hearing argument was going on, they brought this subject also, para 13, page 10. NPSC is making advertisement yearly, lordship, for this assistant professor post. So here, what has happened is that your humble petition respectfully submits that from time to time, NPSC conducts CESE recruitment exam, and whereof some of the petitioners in the previous petitions, as well as the respondents, have qualified in the exam since 2019. They are, while this case was pending since proceeding since 2015. In the midst, this 14 respondent number 1 to 10 are respondents in the previous petitions lodged. I want to project before this honorable court that both the respondent as well as the petitioners who appeared for NPSC have passed. Now, till filing of this writ petition, 14 of them have passed. After this, others have also have passed. But include in this, at the time of filing this is the...
No, this is in the previous petition.
In the previous petition. They are, the opposite parties are saying that we appear, but we got opportunity, but we did not qualify. That kind of allegations were there. The learner senior council
No,
is
no.
laughing.
No, but this is not relevant in the
Yes,
present petition.
but still then both sides of the coin, they also appeared and they are not, they have also passed some of them, so that should not be the issue in this repetition. That is what we are trying to project because it was their ardent argument before the Honorable Court.
Since
So-
you are all eligible, you can appear, you
Yes,
can, you may pass, you may
Yes,
fail.
yes.
Yes.
So this will be my humble submission before the Honorable Court. I don't have to pursue much. Then I will come to the authorities of the land.
Uma Devi, you're relying on Uma Devi, and then what else?
Oma Devi. Then there are lots of I should read out or I should just look 2013-16 SCC 147.
If it's all on the same principle, you can
the
rely
same
on what,
principle.
yes.
If my lord wants me to read out before this Honorable Court, I will. Otherwise, there are so many and
No, no.
what day shall be my day.
If it's on the same principle, then no need. Following Uma Devi.
Following Uma Devi as well as they have also raised the issue of delay and ledges or whatever, but my lord will kindly appreciate that it started in 2015. So at that time they were most of them were only 2 or 3 years when we started filing this petition and pursue on as per the liberty granted by this Honorable Court. So this should not be delay and ledges that is being raised should not be an issue in this petitions.
You mean to say that the petitioners were also petitioners along with account in the PL and all that? Earlier petitions?
In the earlier writ petitions, they were also included in that without challenging their appointment order. In the first writ petition, when PIL was filed, and in the second 706 in all the departments were filed. Unfortunately, this account and all they filed RTI for 2 years, but they did not sought for appointment orders. And they received only the data of all 37 departments. So with that data, after 2 years collection, they filed the writ petition, but since appointment orders were not annexed, that was the reason why, not on merit, but the writ petitions were dismissed twice. So at the end of the day, the Honorable Court again granted liberty and then asked the petitioners to file in a separate writ petition with particular subjects. That is when the present 12 writ petitions have been filed as per the direction of this Honorable Court. So there was no break at all. That is what I'm trying to place before this Honorable Court. Now, 2016, page 147, paragraph 58 to 63. I'll just read out the operative portions. The Constitution bench of this Honorable Court, while dealing with similar issue in respect of executive instruction in Sant Ram Sharma versus State of Rajasthan. It is true that the government cannot amend or supersede because they are also coming on that issue. It is true that the government cannot amend or supersede statutory rules by administrative instructions. But if the rules are silent on any particular point, the government can fill up the gaps and supplement the rules and issue instructions not inconsistent with the rules already framed. 59. The law laid down above has consistently been followed, and it is a settled proposition of law that an authority cannot issue orders, office memorandums, executive instructions in contravention of the statutory rules. However, instruction can be issued only to supplement the statutory rules, but not to supplant it. Such instruction should be subservient to the statutory provisions. 60. Similarly, a constitution bench of this court in Naga People's Movement of Human Rights versus Union of India held that the executive instructions having binding force provided the same have been issued to fill up the gap between the statutory provisions and are not inconsistent with the said provisions. In Nagar Raj Shivrao Karjagi versus Syndicate Bank, this court has explained the scope of circulars issued by the ministry, observing it is binding on the office of the department, particularly the recommendations made by the CBC. 62. In the state of UP versus Dharmender Prasad Singh, this court held that the order must be passed by the authority after due application of mind in uninfluenced by and without surrendering to the dictates of an extraneous body or authority. 63. Considering the case in totality, we are of the view that the appellant have acted in contravention of the final order passed by the tribunal dated 1/6/2012, and therefore there is no occasion for the appellants for passing the order dated 31/7/2012 or any subsequent order. The order passed by the appellants had been in contravention of not only the order of the court, but also the office memorandum and statutory rules. In view of thereof, we do not find any force in this appeal. The appeal lacks merit and is accordingly dismissed. There will be no order as proposed. So this will cover the.
So by this, what do you want to show? That the government cannot supersede the statutory rules?
Yes, statutory rules, regulation, statutory.
By which administrative order?
By the administrative order, they have annexing they will bring up lordship. They are saying that they have been selected or something by this order or that order are also there. So that will, in general, that will cover whatever rules and regulation that have been passed by the respondents is against the statutory rules or law of the land. Then 2011-14. SCC 772. Uh, 107, not sure. Starting from 107. It is a settled legal proposition that if initial action is not in consonant with law, this is regarding the appointment of. It is a settled legal proposition that if initial action is not in consonant with law, all subsequent and consequential proceedings would fall through for the reason that illegality strikes at the root of the order. In such a fact situation, the legal maxim sub lato fundamento cadit opus, meaning thereby that foundation being removed, structure works falls comes into play and applied on all scores in the present case. 1.8. In Bandrinath versus Government of Tamil Nadu and State of Kerala versus Putenkavu, NSS Karayogam. This court observed that once the basis of a proceeding is gone, all consequential actions, orders would fall to the ground automatically. And this principle is applicable to judicial, quasi-judicial, and administrative proceedings equally. 109. Similarly, in Mangal Prasad Tamoli versus Navra Deshwar Mishra, this court held that if an order at the initial stage is bad in law, then all further proceedings consequent thereto will be nonest and have to be necessarily set aside. 10. In C. Albert Morrison versus Chandrasekharam, this court held that a right in law exists only and only when it has a lawful origin. See also Upendranath Gogoi versus State of Assam, Statute Dananda Mishra versus State of Orissa, SBI versus Rakesh Kumar Tiwari, and Ritesh Tiwari versus State of UP. 111. Thus, in view of the above, we are of the considered opinion that orders impugned being nullity cannot be sustained as a consequences. Subsequent proceeding, orders, FIRs, investigations stands automatically vitiated and are liable to be declared nonist.
So you're saying the initial appointment being
Yes,
illegal, the extension orders will also be.
Initial appointment orders are nonist, so everything is. Conclusion 115 is also there, Lordship.
No, but the point is that only.
Yes.
If the initial appointment is
Yes.
illegal.
Then 2014 SCC 50. Oh, 2014 SCC 50 page 50 Lordship. Starting from 8 Lordship.
8.
Page paragraph 8.
Yes.
8. As Article 14 is an integral part of our system, each and every state action is to be tested on the touchstone of equality. Any appointment made in violation of mandates of Article 14 and 16 of the Constitution is not only irregular but also illegal and cannot be sustained in view of the judgments rendered by this honorable court in Delhi Development Horticulture Employees versus Union versus Delhi Administration, State of Haryana versus Bhaira Singh, and Prabhat Kumar Sharma versus State of UP, IAS Inter-College versus State of UP, MP Housing Board versus Manoj Srivastava, MP State Agro Industries Development Corporation Limited versus SC Pandey, and State of MP versus Sandhya Tomar. 9. In Excise Superintendent versus KP Vishwara Rao, a larger bench of this court considered its earlier judgment in Union of India versus Har Gopal, wherein it has been held that insistence on recruitment through employment exchanges advances rather than restrict the rights guaranteed by Article 14 and 16 of the Constitution. However, due to possibility of non-sponsoring of names by the employment exchange, this court held that any appointment, even on temporary or ad hoc basis, without inviting application, is in violation of the said provision of the Constitution. And even if names of candidates are requisitioned from employment exchange, in addition thereto, it is mandatory on the part of the employer to invite application from all eligible candidates from open market, as merely calling the names from the employment exchange does not meet the requirement of the same article of the Constitution. The court further observed in K.B. Vishwa Rao case 6. In addition, the appropriate department should call for names by the publication in the newspaper having wider circulation and also display on their office notice and employment news bulletin, and then consider the case of all candidates who have applied. If this procedure is adopted, fair play would be subserved. The equality of opportunity in the matter of employment would be available to all eligible candidates. 10. In Suresh Kumar versus State of Haryana, this court upheld the judgment of the Punjab and Haryana court, wherein 1,600 appointments made in the police department without advertisement stood quashed through the Punjab Police Rules 1934 did not provide for such a course. The High Court reached the conclusion that process of selection stood vitiated because there was no advertisement and due duplicity for inviting application from the eligible candidate at large. In UPSC versus Girish Jayanti Lal Baghela, this court held 12. The appointment to any post under the state can only be made after a proper advertisement has been made, inviting application from eligible candidates and holding of selection by a body of experts or a special constituted committee whose members are fair and impartial. Through a written examination or interview or some other rational criteria by judging the interses merit of candidates who have applied in response to the advertisement made, any regular appointment made on posts under the state or union without issuing advertisement, inviting application from eligible candidates, and without holding a proper selection where all eligible candidates get a fair chance to compete would violate the guarantee enshrined under Article 16 of the Constitution. 12. The principle to be adopted in the matter of public appointments have been formulated by this court in MP State Cooperative Bank Limited versus Nanuram Yadav as under 1. The appointment made without following the appropriate procedure under the rules, government circulars, and without advertisement or inviting application from the open market would amount to breach of Article 14 and 16 of the Constitution of India. 2. Regularization cannot be a mode of appointment. 4. 3 is not applicable, Lordship. 4. Those who come by back door should go through that door. 5. No regularization is permissible in exercise of statutory power conferred under Article 162 of the Constitution of India if appointment have been made in contravention of the statutory rules. 6. The court should not exercise its jurisdiction on misplaced sympathy. 7. 7 may not be applicable. This is regarding the widespread in examination logic. 8. These are the 8 principles. 8. When the entire selection is thinking, conceived in fraud and delivered in deceit, individual innocence has no place and the entire selection has to be set aside. 14. Instead of Orissa versus Mamata Mahanti, this court deals with the constitutional principle of providing equality of opportunity to all, which mandatorily requires that vacancy must be notified in advance, meaning thereby that information of the recruitment must be disseminated in a reasonable manner in public domain, ensuring maximum participation of all eligible candidates. thereby the right of equal opportunity is effectuated. The court held under 36. Therefore, it is settled legal proposition that no person can be appointed even on a temporary or ad hoc basis without inviting application from all eligible candidates. If any appointment is made by merely inviting names from the employment exchange or putting a note on the notice board, etc., that will not meet requirement of Article 14 and 16 of the Constitution. Such a course violates the mandate of Article 14 and 16 of the Constitution of India, as it deprives the candidate who are eligible for the post from being considered. A person employed in violation of this provision is not entitled to any relief, including salary. For a valid and legal appointment, mandatory compliance with the said constitutional requirement is to be fulfilled. The equality clause enshrined in Article 16 requires that every such appointment be made by an open advertisement as to enable all eligible persons to compete on merit. Let's come to 16, Lordship. Another important requirement of public employment is that of transparency. Therefore, the advertisement must specify the number of posts available for selection and recruitment. The qualification and other eligible criteria for such posts should be explicitly provided, and schedule of recruitment process should be published with certainty and clarity. The advertisement should also specify the rules under which the selection is to be made, and in absence of the rules, the procedures under which the selection likely to be undertaken. This is necessary to prevent arbitrariness and to avoid change of criteria of selection after the selection process is commenced, thereby unjustly benefiting someone at the cost of others. 17. Thus, the aforesaid decision are an authority on prescribing the limitation while making appointments against public posts in terms of Article 14 and 16 of the Constitution. What has been deprecated by this court time and again is backdoor appointment or appointment dehors the rules. 18.
Okay. It's understood. Now you're trying to show that even for temporary appointment,
Yes,
there should be advertisement.
yes. I have so many pointed, but that will be not.
Yeah, that is the main principle. Yes.
2025 SCC online. This is the latest regarding the. My lord has found it.
Yes. Para.
Starting from 31. Para 31. In our view, since the very selection and appointment of the appellant employees was a nullity in the eyes of law, the learned single judge committed no error in directing the respondent state to prepare fresh panel of selected candidates without hearing the candidates who were likely to get affected. In this regard, we are benefited by the decision of this court in Union of India versus Raghuvar Pal Singh, wherein it was held that when the appointment of the candidate is nullity in law, making them entitled to hold the post, the principle of natural justice were not required to be complied with, particularly when the same would be nothing short of an exercise in futility. The relevant portion extracted herein below. For taking this content forward, we may assume for the time being that the then director in charge, S.H. Rathore, agriculture officer, had the authority to issue a letter of appointment Nevertheless, he could do so only upon obtaining prior written approval of the competent authority. No case has been made out. The original application was that due approval was granted by the competent authority before the issuance of letter of appointment to the respondent. Thus, it is indisputable that no prior approval of the competent authority was given by the appointment of the respondent. In such case, the next logical issue that arises in consideration is whether the appointment letter issued by the respondent would be a case of nullity or a mere irregularity. If it is a case of nullity, affording opportunity to the incumbent would be a mere formality, and non-grant of opportunity may not vitiate the final decision of termination of a service. The tribunal has rightly held that in the absence of prior approval of the competent authority, the director in charge could not have hastened issuance of the appointment order. The act of commission and omission of the then director in charge would therefore suffer from the vice of lack of authority and nullity in law. Instead of Manipur versus what VY Token C, 2007-5 SCC 65, 2007-2 SCCLS 107. The appointment letters were cancelled on the ground that the same were issued without the knowledge of the Department of the State. The court, after adverting to the reported decisions, concluded that the candidates were not entitled to hold the post, and in case of such nature, principle of natural justice were not required to be complied with, particularly when the same would result in futility. 32. Hence, in view of the above principle and the factual scenario in the case at hand, it is clear that if the subject appointments were ab initio nullity in the eyes of law, it was not incumbent on the learned single judge to pass the order after hearing all the parties that were likely to be affected by such decision, i.e., the candidates who were already appointed on the subject post, including the appellant employees. 33. Therefore, we are of the view that the learned single judge did not commit any error while issuing a direction by the order dated 12 September 2018 for preparation of fresh panel of selection candidates in consonance with the statutory rules and procedure prescribed in the advertisement, as it is clearly discernible from our discussion in the first issue that the recruitment process was void ab initio and ultra vires the Constitution of India. Therefore, there was no need to comply with the principle of natural justice, as there would be nothing but an exercise in futility, and the appellant employee thus cannot be allowed to claim prejudice from the fact that he was neither impleaded nor heard before the issuance of a direction affecting his service. With respect to the power of cancellation of entire selection process, the court in MP State Cooperative Bank Limited and Nanuram Yadav held thus. It is clear that in the matter of public appointments, the following principles are to be followed. Lordship, I have already read out this one also. It is being upheld even up to 25. The appointment made without following the appropriate procedure under the rules, government circulars, and without advertisement or inviting application from the open market would amount to breach of Article 14 and 16 of the Constitution of India. Regularization cannot be a mode of appointment. An appointment made in violation of mandatory provisions of the statute, in particular, ignoring that this one also covers the Tamlong's case, the previous one. An appointment made in violation of the mandatory provisions of the statute, and in particular, ignoring the minimum education qualification and other essential qualification would be wholly illegal. Such illegality cannot be cured by taking recourse to regularization. Recently, Lordship, it has been withdrawn. Otherwise, even those without qualification were said to be regularized, but that is already kept in the abeyance, Lordship. For those who come back door should go through the door. No regularization is permissible in exercise of statutory power conferred under Article 162 of the Constitution of India if the appointment have been made in contravention of the statutory rules. The court should not exercise its jurisdiction on misplaced sympathy. 7. If the mischief played is so widespread and all-pervasive, affecting the result so as to make it difficult to pick out the person who have been unlawfully benefited or wrongfully deprived of their selection. It will neither be possible nor necessary to issue individual show cause notice to each selectee. The only way out would be to cancel the whole selection. When the entire selection is thinking, conceived in fraud and delivered in deceit, individual innocence has no place and the entire selection has to be set aside. Thus, 35. It is clear that once the appointment process is declared to be a nullity in law, every action taken in furtherance of such appointment process is also illegal. And therefore, the constitutional courts have jurisdiction to set aside such appointment wholly and ab initio. This power of the court is not curtailed even in the situation where a third party right has been created in those who have been offered appointment or have even joined the service. Lordship, I will just 37. 36 is also relevant, Lordship. However, it is very long. 37. It is therefore clear that beneficiary of a backdoor procedure cannot claim proper treatment as per law when they come at the receiving end. Receiving end. 38. In the present case, the appellant employee who had been appointed under the advertisement dated 29 July 2010 does not have any right on the subject post once it is concluded that the advertisement is itself void and is declared illegal and unconstitutional.
This is a case where there was an advertisement.
Yes, this is pertinent. So when even in an advertisement it is this, there was no advertisement in this. Then
Okay.
39 is also very relevant. The latest one, Lordship. para 31, 40.
39.
40 and 41. These are the
Okay,
latest.
okay.
The 13.
You just mark the paragraphs 40, 41.
Yes, 37, 38, 39, 40 and 41. This is the latest.
39, 40.
Then, Lordship, there they have some. Two 2014-13 SCC 323. This is pertaining to those who have served even 15 years also with terminated. They have been on the issue of delay in ledgers. It is not applicable here because the first initial appointment itself is illegal. However, Lordship, in order not to two 2014-13 SCC 232. 232. Paragraph is 7, 8, 9. This was quashed after 15 years of service. 7. The learned counsel for the respondent supported the impugned order and submitted that having regard to the fact that the respondent had already served for 15 years, termination of his service was not called for. 8. The only question for consideration is whether the appointment of the respondent met without any advertisement or selection process can be considered to be a valid appointment to a public post protected under Articles 311 of the Constitution of India. 9. On due consideration, we are of the view that the impugned judgment cannot be sustained for the reason that follows. 10. The order of appointment in the present case is as follows. In the light of the order passed by the Inspector General Police Criminal Investigation Department, Bihar, Patna, by the letter number so and so, Sri Chandra Shwar Pathak, son of so and so of village so and so, district Chapra, was appointed as constable temporarily for 14/1/1988 afternoon on the condition that his previous character found satisfactory, and as and when necessary, his service shall be terminated without assigning any reason or show cause. His pay scale so and so with the basic pay of so and so has been allotted. CT number 390. It is clear from the above order that the appointment has been given only on the asking of the Inspector General of Police. There is nothing to show that any advertisement was issued giving opportunity to all eligible candidates to compete, or any selection process was undertaken before appointment of the respondent. In the state of Orissa versus Mamata Mohanty, it was observed as under appointment, employment without advertisement. 35. At any time, this court has been in the view that calling the names from employment exchange with curb to certain extent the menace of nepotism and corruption in public employment, but later on came to the conclusion that some appropriate method consistent with the requirement of Article 16 should be followed. In other words, there must be a notice published in the newspaper, appropriate manner calling for application, and all those who apply in response thereto should be considered fairly, even if the names of candidates are requisitioned from the employment exchange. In addition thereto, it is mandatory on the part of the employer to invite application from all eligible candidates from open market by advertising the vacancies in newspaper having wide circulation or announcement in radio and television, as merely calling the names from the employment exchange does not meet the requirement of the said article of the Constitution. 36, Lordship. Therefore, it is settled.
Same.
Yes,
here also.
in the
That
same.
no person can be appointed
Yeah,
even on a temporary basis.
Yes.
Mm.
The price of the candidates.
Yes.
13. 13 is also relevant. This will do.
Yes.
Accordingly.
I have marked the para.
So, Lordship, we kindly say this is the appointment was quashed after 15 years of service. 2005 for SCC, 2019. 2009. Thirteen to 15 only, Lordship. 209. 209. 13.
13 to.
13 to.
You just give the relevant paras to save time.
Okay.
And then what is the principle which has been laid down? 13 to 19.
No. After 13 to 15 years of service, they were terminated.
No, para. The relevant para.
13. Yes, this is just a short 13 only.
13 para 13. This one also after working for 15 years.
Yes, Lordship. We therefore dismiss the appeal, but without cost. And here, Lordship, we kindly appreciate that in the last, the High Court has been more generous in allowing the appellant to participate in any fresh selection procedure as may be held in granting a relaxation of age limit. So, On my part, I submit before the Honorable Court age limit, no matter how much lordship, that I have no objection. As per the Supreme Court. Then 2008 one SCC 798. 2008 one SCC. Paragraph 8, 9 and 10, Lordship.
Paragraph 8, 9, and 10. And this is regarding
14 years terminated, 14 years of service in term. Two thousand 11 SCC. 11 SCC 136. 2008 I forgot to.
2011 SSC 136. Para
136. It is pertaining to delay in latches. 46, 52, 50.
46, 52.
56.
No, this 2011 SCC, it is only till paragraph 17.
17.
Only till paragraph 17. Ajay Kumar Das.
This 2011 SCC 136 is regarding 136 is statutory rules cannot be altered. The first one, statutory 12, 13, 14. 12, 14, 12, 13, 14 statutory rules cannot be altered. Then in the same 2000, same 11 SCC 607. Page 607. This will cover delay in legislature. Because they have been raising that issue. Regardless, it started in 2000.
Para
46, 52, 53, 54.
52, 53.
And Lordship, that will have a separate hearing that will 14. Otherwise, the citations that will be separately heard now.
340.
Yes.
And what about the other bunch? These are all same.
Same, just it's all
Only the
same.
petitioners and respondents are different.
All the respondents are different, each subject different. Otherwise, appointment, everything is all the same. And in totality, I have already sorted out how much has been appointed without sanction was, with sanction was, and in all the writ petition, I have put it into the best of my paragraph writ petition. Who are
Against
in
sanction
sanction
and
post, who are not in sanction
but
post.
in this petition, also you have made a mistake because the deputation, that cannot be advertised. Deputation is post.
Yes, in my writ petition, I have stated through MPSC as well as any other mode of advertisement. That means those in non-sanction post, the department without going through NPSC regular
Departmental selection.
the departmental advertisement.
Advertisement.
Yes, only that through other mode. And So if in other petition, there is one in which petition pertaining to the learned senior advocate. But six, two petitions, 189. Before I take my seat, I just want to clarify one aspect. After that, they can submit whatever they want to. In 189, because this is the only issue where the learned senior advocate has placed before this honorable board. Lordship, without qualification citation, I will just refer it later on.
That is in 340.
340.
Then
That will be kept aside.
that will be kept aside for another day.
In the affidavit in opposition.
In WP 189, yes.
Yes.
What
This is
happened?
in respect of respondent number 68189. Political science subject logic.
Yeah. What happened?
This is pertaining to respondent number 6, 8, 10, 12, and 13. My submission before this honorable court is all the same.
6,
6,
8,
8, 10,
10, and
12,
12 and 13.
13. Here they have. The pleadings are all the same. The basis of their sanction, non-sanction, everything is in my petition body, and that who have passed, who have failed, both sides are all the same.
No, but why
you
you
know-
are picking up this particularly, this 189?
13. No, here only the learned council was claiming that it was true open advertisement. That's why I just want to come to this.
Oh, acha.
What advertisement was made?
WPC 118.
Page 7, next year A of their affidavit in opposition. Besides that, whatever they plead before the zonal court, the law is very clear. I have already based my submission and my case raised under Article 141 and 113. Besides that, the OAM's notifications and circulars of the respondent government since 1976 that will cover, and their appointment all carries till NPSC, whichever is earlier, and they were appointed. Some were appointed for 6 months on contract, some 1 year. That has become more than a decade. Now, page 7.
Page 7 of
Of
the
the
affidavit.
affidavit in a position of the respondent number 6, 8,
6,
9,
8,
10, 12, and 13.
yes.
I will just read out this. Next year A. This is the advertisement that they are referring.
No, wait. Oh, this is additional affidavit.
Government of Nagaland, Department of Higher and Technical Education, Nagaland Kohima notification dated Kohima the 12th August 2011. So it starts with this logic. Pending regular recruitment through NPSC. The Department of Higher and Technical Education proposes to make contract / casual appointment of assistant professors and English literature, history, political science, education, economic. What science is this? Economics. Botany science.
Library science.
Library science logic. Library science, physics, and maths at government colleges in Nagaland from among the eligible and qualified candidates. For this, a panel of eligible candidates in all the disciplines is proposed to be prepared after conducting in interview at 11 hours on 23/8/2011 in the conference hall of the Directorate of Higher Education, Kohima. All eligible and interested candidates having the following qualifications are invited to attend the walk-in interview with their original certificates and copies of the certificates. A master's degree with minimum of 55 marks or equivalent grade in a point scale wherever grade system is followed and having cleared the national eligibility test. Provided, however, that candidates who are or have been awarded a PhD degree in accordance with the UGC minimum standard and procedure for award of PhD degree, Regulations 2009, shall be exempted from the requirement of NET. NET shall also be required for such master's degree programs in discipline for which NET accredited test is not conducted. FP Solo, Commissioner and Secretary to the Government of London. So this was the departmental advertisement where it starts and says that pending regular recruitment through NBSC. So
which shows that it's for temporary appointment.
yes, it is a temporary appointment. So
Yes.
whatever post they have been appointed has to be now. It is 2011. Now already 14 years. For a temporary appointment, it has become to 14 years, Lordship. And all these irregularities and illegalities has to go in the Department of Higher Education. And this department being the elite teaching faculty, Lordship, this menace of backdoor appointment has to stop. And it is not because they were appointed after 6/6/2016, or it's not about appointing prior to 6/6/2026. There should not be any differentiation because at the end of the day, all appointments were made void ab initio. So it is all the same, whether before or after 6/6/2016, Lordship. And once and for all, I pray that this honorable board, these are the humble submission of the petitioners before this honorable board to do away with illegality.
One minute. Yes, now we'll come back to 188.
It's one Lordship. Also, we have to be very clear what is the prayer of the petitioner. The prayer of the petitioner is that to question set aside the appointments of the private respondents and to advertise the post which the private respondents are holding. So the private respondents are all holding a non-sanctioned post. Whatever sanctioned posts.
Some are sanctioned.
No, they are sanctioned posts. So all those sanctioned posts, apart from the deputation, the retirements, or other vacancy, has already been requisitioned to the NPSC and it has already been advertised. I have annexed the advertisement also in my affidavit in opposition, Lordship. Affidavit in opposition.
Number 1, 2, 3, and 4.
Yes. Page 9 to. Page 9 to 31 and 38 to 43. These are the advertisements to show how we have been advertising the post, the section post. New post creations, Lordship. No, it's on the. No, these are not on. No section. These are not the newly created section posts. These are the vacancy section posts. Where we have been advertising since I have annexed since 2013.
some of the advertisement to show. And the present case is not a question of regularization also. My learned friend has shown the Supreme Court judgment also so much basing on the regularization. But here
No,
is the
but if
question
it is
of-
advertised,
Yes.
then how come you are still continuing, the private respondents are still continuing?
Exactly. No. So,
189.
It has to be filled up as per the advertisement.
So we have filled up the post. And what the
Then-
petitioners are.
Then if it's filled up, then how can they continue?
So Lordship, for that matter, in exigencies of services, we have shortage of college teachers. We have shortage, and I have mentioned here in my affidavit in opposition, page 70. There are 15 government colleges and two state college of teacher education in Nagaland. Page 7 of my affidavit in opposition. So we have 491 regular assistant professor, 491, and we have 145 contract fixed assistant professor in 15 government colleges and 5 contract fixed assistant professor in the 2 college of teachers educations. So Lordship, we don't have the sanction post. And the number of the students are increasing year by year. So in order to tackle with the shortage of the teachings, we, on the basis of the students, we have appointed the private respondents in a specific subject as per the regulation of 2000 UGC 2010 and 2018 regulations.
Okay, fine, the regulations provide for contract appointment, but you cannot just pick and choose and appoint anyone.
So, Lordship, for that
Yes.
matter, I may be allowed to read my affidavit in opposition. May kindly come to page 2.
Yes.
Page 2, paragraph 5. That the amendment made in paragraph 3 of the writ petition, the deponent submits that the non-sanctioned post cannot be requisitioned to MPSC since there is no post. The sanctioned post vacated on retirement, etc., were all requisitioned to MPSC for advertisement. Then come to page 3, para 8. That with regard to the statements made in paragraph 7 of the writ petition, the deponent states that on considerable observation of all the government colleges in Nagaland, there is a shortfall of teachers in different subjects. And as there was no sanction post, the deponent authority approached the government as some of the candidates applied for assistant professor librarian, of which the candidates acknowledged the terms and conditions of the government, nature of appointment, and willing to avail their service on a mere fixed pay, purely on temporary basis, and to be terminated as and when the government pleases. The deponent authority has recruited the minimum qualified candidates on fixed pay on the approval of the government and as provided under UGC Regulation 2010 at Regulation number 13 and UGC Regulation 2018 at Regulation number 13, appointment of teachers on contract basis under the Higher Education Department to meet the urgent requirement of the colleges. The appointments of the assistant professors on contract basis were engaged due to exigencies, as unlike the other government departments, the Department of Higher Education functional learning institution where a vacant post of a subject teacher may create unknown difficulty and directly affect the students. Respondent number 5 was appointed on contractual basis against post vacancy due to expiry of the incumbent, and the said post was constituted for walk-in interview for regularization, which was held on 8/9/2016 by the screening committee. Respondent number 5 has attended the interview. However, till date, he is not being regularized and the post has been lying vacant. Respondent number 6 was appointed on contractual basis against the deputation vacancy of Sriti George Kire, Associated Professor, Dimapur Government College to NPSC. Until date, the post has been occupied by the said Associated Professor. Respondent number 7, 8, and 9 were appointed on contractual basis against non-sanctioned posts. Respondent number 10 was appointed on contractual basis against retirement vacancy, and the said post was requisitioned to NPSC on 25/5/2017 by the department. So Lordship say, whatever vacancy arose in the department, we have been requisitioning to the NPSC for advertisement. And whatever posts are, they are not holding a post. There is no sanctioned post.
No, but even then, there has to be some selection process.
Lordship, if that is the case, then let the petitioner show as to how, even for the non-sanctioned post, there has to be a selection process, because when they are not holding as a post.
No,
Because-
that's what the Supreme Court is saying, even temporary
No,
ad
there-
hoc, anybody.
It's in regard to the sanction post. Because for the non-sanction post, it's the discretion of the government. If it is a sanction post, we have to follow the rules, the procedure.
So what rules and procedure were followed?
For this matter, since the UGC has given us the
No, UGC regulations clearly says as the selection method as for regular appointment, which means there has to be a process, there has to be an advertisement.
Lordship, if that is the case, then I leave to your lordship
Yes,
for that
yeah.
matter, even for the non-sanctioned post. But what-
Non-sanctioned post, even if it's a non-sanctioned post, they are getting salary, even if it's a fixed salary, they're getting salary. Even if it's a 5,000 rupees salary, even for that, there has to be an
If
advertisement.
that is
Yes.
the court.
No, that is not
Yes.
the court stand.
That's-
That is what the Supreme Court
Is
says.
that, even the petitioner also can submit their application to the department, and if there is. If there is, because I clearly. see-
Unless it is publicly advertised, how will they know that there is that there is requirement? There is requirement for it.
Submit the applications, and if there is an urgency, then we can, on the basis.
No, that is not proper. That is not proper. So that is your main stand, that these are non-sanctioned.
Only a sanction post, so the sanction post need not be requisitioned to the MPSC for advertisement.
Then what about 189? There was an advertisement, even if it was a temporary contractual appointment, but they are continuing. And the advertisement clearly stated that till it is requisitioned to the NPSC.
Otherwise, Lordship, if you come to my affidavit in opposition at page 4, paragraph 11. That with regard to the statement made in paragraph 10 of the relief petition, the deponent is to submit that respondent number 7 and 11 were appointed on contractual basis against study leave vacancy of Srimati Kalitoji Shi, Assistant Professor Political Science, Tinuboto, Government College, Tinuboto.
Oh, this is 189.
Yes, 189. And Sri Amos Ovun, Assistant Professor Political Science at Mount Meagy College, Wokha. Therefore, on completion of the study leave, the post is automatically occupied by the said assistant professor. Page 5, respondent number 8 was appointed on contractual basis against voluntary retirement of B.R. Chitri, Vice Principal, Peck Government College, Peck, and the post was requisitioned to NPSC on 15/4/2014. Respondent number 9 was appointed on contractual basis against the attachment of Srimati Purtila, Assistant Professor, Wangkau Government College to Dimapur Government College. Hence, the sanction post is still occupied by the incumbent. Respondent number 5, 10, 12, and 13 were appointed on contractual basis against the non-sanctioned post.
But
So what would be
but
the-
in the advertisement,
The sanction posts were already requisitioned to the NPSC.
because
So even if they are continuing on a non-sanctioned post.
see, in this 12 August 2011 notification, it says pending regular recruitment through NPSC. The Department of Higher and Technical Education proposes to make contract casual appointment. So in pursuance of this, the private respondents were appointed, isn't
Yes.
it?
Yes.
So now, pending regular recruitment through NPSC. So after that, you have requisitioned
Yes, Lordship, because this is a notification that the
2011.
2011, and I have annexed the advertisement of some of the years of starting from 2013 to 2022.
So which
So if
means
there are continuing means they are
then,
continuing on.
then how are they
sending
continuing?
posts. They are on because of the exigencies of their service. Because we don't have a sanction post. So we have to appoint them on a contractual basis, give them extension so that they tie up with the teaching
This is a big
of
mess.
the students in the colleges. Because we have only 491 regular sanction posts in the 15 colleges, and there's a shortage of
No,
teachers.
okay, it's understood that contractual teachers, professors are required.
Yes.
That is fine. But how to recruit them? That is the thing. You cannot just choose anybody. Even it's a non-sanctioned post, even if it's a temporary contractual, whatever it may be. That is the only question.
Otherwise, Lordship, in my 188,
Mm.
in 188, the Nagaland University of my academic institution. At page 73.
Mm.
This is for the professional and non-professional
Mm.
regulation for introduction of PG program and college affiliated to Nagaland University 2021. My lady will come to point 12, principal and faculty.
Faculty. Yes.
Here, principal and faculty.
Mm.
A, qualification and number of faculty. We are concerned with one, the qualification for principal and teacher shall be as prescribed by the UGC regulatory body of government of India from time to time. Number two, at least 10 teachers, 5 for UG and 5 for PG in science stream. Number three, at least 8 teachers, 4 for UG and 4 for PG other than science stream teacher. So these are the minimum strength of a teacher should be there in our colleges. So we don't have this strength for which we appoint the private respondents to tie up with the exigency.
Total sanction posts as of now?
Total
you're
sanction
saying?
posts as of now is 491.
491.
Yes, and the
For how many colleges?
15 colleges.
15 colleges.
And 33 regular assistants in the 2 state college of teachers education.
What is this? Any regulations for introduction of PG program in colleges
Regional.
affiliated? The one you were reading just now, page 73.
73, yes. This is the regulation for introduction of PG program in colleges affiliated to Nagaland University. So the minimum faculty, number of faculty teacher in a college prescribed by the Nagaland University. It's mentioned at, well, in my faculty. Otherwise, my lady, if you come to page 7, I have clearly mentioned. Page 7, paragraph 15. That by letter number such and such, the director has answered to the court's query number 1. There are 491 regular assistant professor and 145 contract fixed assistant professor in 15 government colleges. In the 2 state college of teachers education, there are 33 regular assistant professors and 5 contract fixed assistant professor. Court query number 2. In most of the government colleges and resignation against sanction posts, where in such case the contract assistant professor tied up the vacant post. The sanction post creation were requisitioned to NPSC to conduct exam, and while in process, still the filling up of the vacant post by the qualified candidates on recommendation by the NPSC, the contract assistant professor services were extended on exigency since there is shortage of teachers in almost all the government colleges. The colleges permanently affiliated to the Nagaland University for introduction of PG program, where the Nagaland University has issued Regulation 2021 for introduction of PG program in all the affiliated government colleges to meet the qualification, and the number of faculty were adjusted by the contract assistant professor. As per Regulation 12A of the Nagaland University Regulation 2021, at least 10 teachers, 5 for UG and 5 for PG in science stream, and at least 8 teachers, 4 for UG and 4 for PG other than science stream. Then page 8, court query number 3, the payment of salaries were paid under the categories of wages as fixed to the various contractual appointees as assistant professor and not as per the UGC regulation. Then my lady may turn to page 71. This is the regulation showing the number of contractual teachers and the regular teachers. These are the details of summary of government colleges for the 2 state college of teachers education. R stands for regular and F stands for fixed. Yes. So in the education that we have in Kohima, we have 7, fixed is 1, Mokokuchung we have 3, and we don't have fixed. So likewise, the double breaking has been made. And in page 72, these are the 15 government colleges doing.
Page
Yes,
71 is
72.
the 2, what colleges? This 71?
Page 71 is State College of Teachers Education.
Okay.
Yes, 1 in Kohima and 1 in Mokokuchung. Yes.
Then
And
this
page
page
72
is
is the 15 government
15
colleges in
colleges.
Nagaland. So the number of regular assistant professor and the fixed in respective subjects has been break out. So it comes to regular teachers have 491 and fixed 145. The total comes to 636.
Not related to the petition, but is the department pursuing for creation of post? Has any proposal
Yes,
been made?
Recently,
Recently also post creation, that is new post creation.
yes,
And at the time when we filed a writ petition prior to this, we challenged the state government for they created post assistant professor post, but it was not advertised. That's why we challenged. While it was under challenge, the posts were advertised, but that also post creation, newly post creation. Now the learned council is saying that the additional advocate general is saying that it is all non-sanctioned post. However, they are saying that they have sent in 2017 or 2000 this and that, but all the respondents are still holding the post, Lordship. That is the
No, they are not holding the post. They are
the post.
non-sanctioned,
non-sanctioned.
and they're getting fixed pay,
Yes,
which means
on that issue, as my lord has already suggested, we are not on their appointment, but we are on the issue of even in my prayer itself.
all along you're saying to terminate their service,
Yes,
and now you're saying
the service and issue an advertisement. One, if it be a sanction post, it should be through and BSc. If it is not a non-sanctioned post, I
Then
have written
departmental.
let the department advertise the post, and that's all. That is only our case. I don't have any other issue, Lordship. Only on the issue of advertisement. Otherwise, they cannot keep on appointing in a non-sanctioned post any Tom, Dick, and Harry. That is in violation of Article 14 and 16, Lordship, and it has to be stopped. This precedence has to be stopped, Lordship. That's all. I'm not against any other
Yes,
issue.
okay. Then what else?
Yes. Otherwise, to your, that would be an off record, but to your lordship, query, I think it was last year. Some posts were
Created.
created and they have
But still
regularized
not
it.
enough.
So now all those things has been revoked. So now there is no post creation. Yes.
There is, just recently, there is something advertising just instantly. That is also, the cabinet has created a post. 100 and something, I'm not sure.
Otherwise, the stand of the government is that since they are holding a non-sanctioned post, the questions of an advertisement against those sanctioned posts does not arise or does not require. And whatever sanctioned posts are lying vacant, we had already requisitioned to the NPSC for recruitment. That's all. Budget.
Already sanctioned. And your advertisements starts from page 27.
Page 931 and 38 to 43. 9 to 31,
9 to
31 and 33, 38 to 43.
28 to 42.
I have missed out some of the advertisement of 2018 and 19, but the rest also, everything contains the same.
The rest, can we continue on Monday? Yes, it's already 3:30.
Better lordship, because continuity will be more.
Yes.
Lordship.
Then I'll be out of station next week, and since my submission has completed.
Yes. And you tell Vizimomi to be there so that we can hear the other petition.
In the meantime, I can also bring some clarification.
That is always open.
That is open to everybody.
Even before make our submission, my element plan has referred to the remove that goes.
Of course.
So also prepare our agreement.
That advertisement. Albert, itu kan Pina. Ordering this. This is item 4. No, yes, item. No, item 5. We heard item 6. No, I think item 6. Yes, heard learned counsel with the petitioner, Miss Zetrimoni. Also heard Miss Vishukri, learned additional AGs for the state respondents. The matter is part heard. We fix on Monday will be 13th. 13th then as part heard. Yes. We have some more matters.
For admission, item number 33.
Item 33.
May I please about it?
Yes.
Eventually, on behalf of the teams on, then think it's like, Lordship is here to file an application. Lordship, this will set my time to.
Learned Council, Learned Governing Council, Mr. Vichimomi, who makes a mention on behalf of Mr. Im Tim Song, additional AG, to list the matter after 3 weeks as he is yet to file the counter affidavit on behalf of the state respondents. Learned counsel for the petitioner, Mr. Forgetting your name, yes, James Newby, on behalf of Moa Jamir is present and has no objections. List after 3 weeks.
For admission, item number 43.
Also here, there is formally, we have
Mm.
yet to receive instruction from.
Hmm.
Mm.
How much time? 3 weeks. 3 weeks. Learned counsel for the petitioner, Ms. Jao Mong is present. The learned government advocate, Mr. Vijimomi, prays for 3 weeks' time to file the affidavit in opposition.
Instruction, I'm yet to receive.
Yet to receive instruction.
But-
That means on the next occasion, you'll be asking for more time to receive instruction and to file the affidavit. So list after 3 weeks as prayed for. Yes. Any more?